Good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is August 10th, and it is about 9:34, running a couple minutes late. Apologies for that. We are going to initiate today's meeting with a roll call.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez.
Here.
Commissioner Hackett, Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Great, thank you. And Commissioner Bogue and our commissioner from CDPHE are both excused from this hearing. And so we have a quorum. We're here today to undertake our agenda, which is the final, a hearing on docket number 2011000261. I believe it would be appropriate, Hearings Manager Larson, if we brought both counsel for staff and counsel for the defendant to the table.
Yes, we will make sure that they are in. Give us one moment. Mr. Chair, Mr. Jacobs is in, and we see Mr. Mueller in the attendee list. I've been trying to promote him to a panelist, and Zoom is not allowing it. Oh, there we go.
Okay, Mr. Jacobs, if you could unmute, could we make sure we can hear you?
Yes, Mr. Chairman, thank you. Hearings Manager Larson. I believe we still need a couple of my colleagues who are counsel of record. That would be my associates, Lucas Satterley and Sarah Carlson, promoted to panelist, please.
We're working on that, Mr. Jacobs. Give us just a sec, and then once we get everybody on board, I'm going to have everybody just introduce themselves so we can make sure we can hear folks, if that works.
Great, thanks so much. We're standing by.
Same goes true for staff, if they could be ready to unmute and show us their faces.
Good morning, commissioners. I believe we have all of our representatives here.
Good morning, commissioners. This is Jeremy Farron.
Morning, Kelly Rosenberg, Enforcement Officer.
Morning, commissioners. Ross Watsman, General Counsel for KPK.
Great, thank you, Mr. Watsman. We can hear you. So, Mr. Jacobs, I've got yourself, Mr. Watsman, Mr. Mueller. I see Sarah Carlson as well. If she wants to just introduce herself, make sure we can hear her.
Good morning, all. My name is Sarah Carlson, appearing also on behalf of KPK.
Okay. Do we have your full script, Mr. Jacobs, at this point?
I believe Mr. Satterley is the only person AWOL from our team.
And Mr. Jacobs, we do not see Mr. Satterley yet in the meeting.
We will work on that. Oh, he joined a different Zoom meeting. Apologies. If you'll give me just a moment, I'm going to mute and give him a call.
Thank you. And if we need to resend the credentials to him, we're happy to do so.
Commissioners, I don't think I introduced myself. I'm now unmuted. I'm Kirk Mueller. I'm a partner of John Jacobs, and the other attorneys here at Davis, Graham and Stubbs.
Great. Thank you, Mr. Mueller. We can hear and see you.
We see Mr. Satterley now, and we will get him in as a panelist.
Thank you. Sorry for the delay.
Mr. Satterley, if you could unmute and video and let us introduce yourself, please.
Hi, Lucas Satterley, Davis, Graham and Stubbs, outside counsel for KP Kaufman Company.
Okay, I believe we have the full vote for the defendant, and looks like we've got the full vote for our staff, or for the staff. Just to start, and everyone, this is a first for us in terms of a contested enforcement hearing. Would like to suggest perhaps some ground rules for purposes of appearing. If you are speaking, I would appreciate you also having your video rolling so that we can see you. If you are not speaking, I don't know that we need to see your video, and if you can make sure that you are muted, that way we can focus on the folks that are speaking. Does that work? I'll turn to head counsel for staff first, and then head counsel for KP Kaufman.
Chair Robbins, that works for us. Thank you.
Chairman Robbins, John Jacobs, I believe that works fine.
Okay. If we need to alter the script as we move through this, we'll do that. We'll try to be nimble and make sure that we afford all appropriate things. So we want to start this morning. I'm going to start with taking up a motion that was filed yesterday morning. It is a motion to recuse me as chair from hearing this matter. Essentially, this was filed by KPK, and they make the argument that 2 of the NOAVs at issue were issued at the time when I was director of the commission, and a 3rd NOAV was issued shortly after my not being a director and being chair. And as a result, the argument is that I have a conflict of interest under Commission Rule 514 and should recuse myself. While I was not involved in enforcement while I was director, generally speaking, nor was I involved with the decision to issue the 2 specific NOAVs that issued while I was director. I also note that since issuance of the NOAVs, I have not been involved in prosecution of the NOAVs. I had discussion with then hearings manager Mimi Larson, and there was not a policy in place during the time that I was director in which all NOAVs were brought to me as director for review and sign off. I also note for the record that I do not recollect reviewing or signing off on the 2 referenced NOAVs at issue, nor do I recollect the 3rd NOAV that issued shortly after I became chair. I believe my lack of involvement and my lack of knowledge of the NOAVs allows me to be capable of judging the NOAVs fairly and does not create in me an unalterably closed mind on the matters critical to the disposition of these proceedings. In fact, until yesterday morning, until the dates were brought to my attention yesterday, I had no knowledge of the coincidence of my being director at the time enforcement team issued the NOAVs. I did late last night, and I have to say I'm a little disappointed at the timing of this motion because KPK obviously had this information with it, and unfortunately this has caused me to sort of scramble to sort of go back and figure out what happened or did not happen. With that said, last night I did undertake a search of emails for any mention of the NOAV staff issued to KPK while I was director, or that 3rd one that issued shortly thereafter. Through that search, I learned that at various times in 2019 and the first half of 2020, I was copied on communications between staff, KPK, and members of the public related to one of the NOAVs. I frankly do not have any memory of reading these emails when I received them, and I did not find any email where I communicated directly with staff, KPK, or any other person. In other words, I didn't hit send on an email back. I just was copied on some of these emails. I also did not request to be copied on these emails, nor did I instruct staff to keep me apprised of enforcement matters against KPK. Citing KPK's case law, I can state that I did not participate personally, nor did I participate substantially as a public officials in the NOAVs. Now, having said all that, notwithstanding the fact that I have no actual bias in this matter, and the fact that I believe that I can fairly judge this matter, I note Rule 514 of the Commission rules, which says that in our conduct, we should at all times promote the public confidence in the integrity and impartiality of the Commission. And I also am aware, as a practicing lawyer, that a judge should recuse himself when there is even no actual bias, but a reasonable person could find an appearance of bias based upon the circumstance. Based upon the appearance issue, I will recuse myself from the 3 NOAVs. That is 4022068828, 402363430, 402373684. I do not plan on recusing myself for the other 5 NOAVs. And at this time, I would suggest that we bifurcate the proceedings, that we hold the hearings on the first 5, that we close the record, and then I would recuse myself, and then we would hold the hearings on the final 3. Realize this is a little game day call here and trying to figure this out, but we are trying to honor the rule that I cited. With this decision to recuse on 3 and to hear these matters through a bifurcated matter, I now ask Mr. Jacobs if he and his client are satisfied and would withdraw the motion to recuse on the other 5. So Mr. Jacobs, the question is for you and your client.
Thank you, Mr. Chairman. I appreciate your acknowledgement of the appearance of bias in the case law. With respect to that, you did serve effectively as prosecutor in your role under Rule 523, even though checking emails and not having a personal recollection of involvement, you've satisfied yourself that you have no actual bias. It's that appearance or apparent bias that is controlling. I would also point out that related proceedings require a judge's recusal when they've been a prosecutor. The consolidation of these matters for a single hearing by action of this commission makes them related. There are general exhibits, there are general arguments as to all of these. We have a interim decision of the hearing officer that simply defers allegations of a pattern of violation and knowing and willful violation that connect all of these, that would likely connect all of these, or at least similar violations as between these NOAVs. And so I do not think, while I appreciate very much and respect your judgment and application of the case law as to the 3 NOAVs in particular, that it would appear in your role as director, you had the authority to approve the issuance of those NOAVs, and they were signed by your staff designee. I think that the other 5 are now related proceedings, and that you should be recused from all NOAV, OFB hearing proceedings. Furthermore, as expressed in the motion and in our proposed order, I believe that requires that you be, if recused at all, you be recused from further communication with staff, council, and your fellow commissioners regarding these NOAVs until this OFB hearing is concluded. Only then are you not wearing both your judge hat right now and your prosecutor hat, or picking which one you're going to wear. Because as you're recused, you may be conferring with and consulting with Director Murphy and Ms. Stafford and contributing to the prosecution of the other NOAVs, and that would be impermissible. So while I, again, appreciate very much your thoughtfulness, your sincerity about and in belief that you have no actual bias and your diligence in checking that, I do not believe that is adequate. We are not going to withdraw our motion to disqualify. And as to timeliness, I would just point out that at the beginning of all your proceedings, you typically have commissioner disclosures, regular meetings, rulemaking meetings, hearings, and enforcement hearings. It's not on this agenda, but I would say from our perspective, our motion was a day early. We conferred with counsel as required by the order on motions issued by the hearing officer. And while the timing is not optimal, it was necessary. So we stand by our motion to disqualify, respectfully.
Thank you for that information. With that, I then would turn to AAG Davenport and my fellow commissioners. I believe that pursuant to Rule 514B2, my fellow commissioners will need to determine whether I should recuse myself from the consideration of the other 5, because I do not voluntarily recuse myself. I find no bias. I find no appearance of bias. I'm wearing a judge's hat only, but I will defer at this point to AAG Minor to organize the next step, which I believe is a discussion and vote by my fellow commissioners. And with that, I will turn my speaker off.
Thank you, Mr. Chair. Commissioners, I'll direct your attention to Rule 514 in our current rules, which provides that 514B2, which provides that upon the assertion of a conflict of interest, the commissioner may first voluntarily choose to withdraw. If the commissioner does not agree to withdraw, the other commissioners will vote on whether a conflict of interest exists, and that such vote will be binding on the commissioner with the alleged conflict. So at this point, commissioners, it is up for a motion and vote from you as to whether or not to require Chairman Robbins to withdraw from the remaining 5 NOAVs and effectively grant KPK's motion, or alternatively to deny KPK's motion as to the other 5 NOAVs, which Chairman Robbins has not voluntarily withdrawn.
Why don't you run as chair and acknowledge folks?
Thank you, Mr. Chair. Commissioner Messner.
Thank you, Mr. Davenport. So Rule 514 indicates Commission's decisions must be free from personal bias, and that its decision-making processes are consistent with the concept of fundamental fairness. In determining whether this is a conflict of interest that warrants withdrawal, the Commission members will take the following into consideration. A, whether the official act will have a direct economic benefit to the Commissioner. B, whether the potential conflict will result in the Commissioner not being capable of judging a particular controversy fairly. C, whether the personal conflict will result in the Commissioner having an unalterably closed mind on matters critical to the disposition of the proceeding. I find no evidence in either the motion or the testimony that would indicate that any of these considerations have been met, particularly as this Commissioner, as the chair, has no recollection of the NOAVs and no representative from the operator has any evidence of correspondence with the Commissioner on these matters. With that into consideration, I move denial of this motion.
Commissioner McGowan.
Sorry, could I clarify? I'm not sure that there's a motion, so I just want to make sure I understand if there is a motion. And if there is a motion, right now we're just talking about the 5 that Chair Robbins, regardless of what hat he had on, has not been involved from a prosecutorial position.
Yes, Commissioner McGowan. So Commissioner Messner did just make a motion to deny.
That's his motion. Okay, sorry, Commissioner Messner.
To deny.
Are you just talking about the 5?
Yes, Commissioner
Okay.
McGowan, we are only discussing the 5 NOAVs from which Chairman Robbins has chosen not to withdraw and asserted that there is no actual or appearance of bias for those 5 NOAVs. So at this point, Commissioner Messner has made a motion. I
I will second that motion.
Okay, thank you. Motion made by Commissioner Messner to deny KPK's motion as to the 5 NOAVs from which Commissioner or Chairman Robbins has chosen not to withdraw, seconded by Commissioner McGowan. It's appropriate now if there's any additional discussion. Commissioner McGowan.
Thank you, Mr. Chair. So I agree with Commissioner Messner's review of the 514 rule. In addition, I don't think that from my perspective as a commissioner, I've been told that Director Murphy is a witness. And so I have not been communicating with her, as I think none of the commissioners have, about this hearing. And so I assume that Commissioner Robbins has been given the same instructions. My questions have been going to AGG Davenport. And so from that perspective also, I don't think that there is a conflict of interest for these 5 NOAV considerations.
Mr. Davenport, I realize that you're entertaining discussion among the commissioners and that there's a motion and a second. But if I might be heard before a final vote, I would appreciate it.
I appreciate you acknowledging me, Mr. Jacobs. I think that's not really my call, at least as I see it. Commissioners, if you would like to hear from either Mr. Jacobs or counsel for staff at any point, that's your decision. At this point, I'll try to keep things organized as best I can. I think I'd see if commissioners have any further comment at this stage, and then turn it over to see if you'd like to hear from the parties any further before you vote. Does any commissioner have an opinion on hearing from the parties? I saw Commissioner Najapa unmute first.
Thank you, AG Davenport. I was more just going to continue the conversation that I also support the remarks that Commissioner Messner made, and similar to what Commissioner McGowan said, I believe that, we are all instructed similarly to not discuss the details of this case with Director Murphy or AAG Stafford. And that said, I don't have a problem with hearing from the other counsel, but I do not, I also support the reasons that have been given for the motion that Commissioner Messner has made.
Commissioner Gonzalez.
Thank you, Mr. Davenport. I'm reading through this rule, and I appreciate Commissioner Messner kind of outlining it. As it currently stands, I don't know where any of these 3 under 514B3 would apply in this case that I can see from what I've heard. That being said, I'm always open to more information. If we can put a small limit on it, I'd support, maybe 60 seconds for each council to give their comments before we take a vote.
Commissioner Messner.
Thank you, Mr. Davenport. While I appreciate Commissioner Gonzalez's consideration of additional testimony, I do believe that the motion to disqualify provided the evidence that needed to be considered in this particular motion, and so I'm not seeing any benefit for any additional testimony on this particular item.
Well, commissioners, at this point, unless there's any strong objection, I think we have 2 commissioners who said they'd be willing to hear from counsel and 1 who expressed an opinion. Normally, I think this would be a chair call, but since we don't really have an acting chair, I will just say, based on this straw poll, we'll hear from counsel unless a commissioner wants to make a very strong objection. Otherwise, And given that it's the movements, or given that it's KPK's motion, we can hear from Mr. Jacobs first and then from AAG Stafford if she'd like to give some perspective. I think, though, Mr. Jacobs and AAG Stafford, there's definitely been a clear expression to please keep it brief.
Understood. Thank you very much, Mr. Davenport and commissioners. I believe that 514 is fine as far as it goes, but it does not consider the relationship of these different NOAVs, which are now joined at the hip inexorably by the motion of this commission in early June on an expedited motion, which we opposed. There are now allegations of pattern of violation and knowing and willful violation. And staff has already indicated through exhibits to which we have objected that they intend to put forth evidence of alleged patterns of violation and knowing and willful violations as between the 3 NOAVs and the other NOAVs. These are related proceedings now. The chairman served as the director, in effect, the prosecutor for all enforcement actions under your very own Rule 523B, and he now sits as a judge. He cannot recuse himself from 3 if staff wishes to show a pattern with respect to some of those 3 and some of the other 5. So this is a flawed attempt at isolating the 3 NOAVs for which there is apparent bias under the case law. And that apparent bias is not mentioned anywhere in Rule 514. As good a rule as it is, and as aspirational a goal as it is for promoting the integrity of these proceedings and fundamental fairness, and that language is in there, I don't quote it verbatim, it does not speak to the case law. So it is silent on that. And Commissioner Messner's reference to 514 is therefore not all encompassing. The case law needs to be considered. The apparent bias is clear from the relationship of being the director and now the chairman, sitting as first prosecutor and now judge. And by action of this commission and the allegations of staff, linking them all together in this hearing quite deliberately, they are now related proceedings. And a judge in a civil court would see that and recuse the chairman from all 8 NOAVs, in my opinion. And I think you need to consider that. Thank you very much for the opportunity to be heard.
AAG Stafford.
Thank you, AAG Davenport. Here staff disagrees with KPK's characterization of this proceeding. Staff would like to note that this objection to Chair Robbins presiding over this proceeding comes very late. These matters have been noticed and consolidated since April 2021. It is August 10th, 2021, and we are now hearing about KPK's concern with Chair Robbins' apparent bias. Staff is very confident that Chair Robbins can make a decision on his own, taking into account concerns about the discussion related to pattern of violations. I'm sorry.
Did Ms. Stafford just freeze for just me, or did she freeze for everybody?
She froze for me as well.
I need her to go back maybe a minute and restate, please.
Can you see me now?
Yes, we can.
Okay, I apologize for that. Could you let me know where you lost me?
If you could perhaps just start over.
Thank you. Okay, so starting again, staff disagrees with KPK's characterization of the proceedings here. We note that KPK's objection to Chair Robbins presiding over these matters comes very late. This matter was noticed consolidated in April 2021. It is now August 10th, 2021, and KPK is bringing this concern before the commission. The commission accepted this proceeding on June 2nd, 2021. Again, it is August 10th now. KPK had months to bring up these concerns about bias. Secondly, with respect to Mr. Jacobs's concern about pattern of violations and discussions regarding those, as already indicated in the final pre-hearing order, any discussion about those particular issues will be had if violations are determined by the commission and they will occur at a later date. Staff is confident that Chair Robbins can make a decision regarding his own potential bias in this case, and we ask that KPK's motion be denied here. Thanks.
Brief response, please, on the timeliness issue only, which I did not address.
Apologies. Commissioners, any objection to a brief response from Mr. Jacobs on the timeliness issue alone? Seeing none, Mr. Jacobs, please go ahead.
Thank you. The Colorado Rules of Civil Procedure do not specify the time when a motion for disqualification should be filed. Waiting until after an adverse judgment has been issued may constitute waiver, and other cases have held disqualification motions to be untimely when they were filed a year or later from the time that grounds for qualification were known. Stafford responded about us knowing this for months. We've only been counsel as substitute counsel since late April. This is not untimely under your rules or under the Colorado Rules of Civil Procedure, and I direct you to the case of People ex rel AG 262 Pacific 3rd 646 as an illustrative case. This is not untimely. Thank you.
All right, thank you, counsel. Commissioner Gonzalez.
Thank you. In response to the comments from Respondents Council, it's my understanding that we had a motion to strike or otherwise continue this matter, and that the hearing officer issued an order to bifurcate some portions of the consideration, specifically of staff's requested relief, and specifically as to the pattern of violations, and to bifurcate that outside of this current hearing. In my understanding, kind of the effect of that is that we are essentially hearing all these together, but in terms of viewing them all as a whole or as a pattern subject to that bifurcation, that we have essentially sort of unjoined them. And that in that regard, the way I'm considering it is I think that we can hear, the 5 that Chair Robbins has not recused himself from, and the 3 that he has recused himself from, kind of in those groups, and I think that could accomplish what we're talking about here. Anyways, I wanted to throw that out and make sure I was on the right page. AAG Davenport or any of my fellow commissioners can correct me on that.
Thank you, Commissioner Gonzalez. Commissioner Messner.
Thank you, Mr. Davenport, and thank you, Commissioner Gonzalez. I do concur with you in that analysis. I also will clarify this commissioner's opinion that under the same criteria that I indicated in my motion, I would also opine that it is this commissioner's opinion that the director need not recuse himself from any of the NOAVs being reviewed. The fact that he is volunteering to recuse himself from 3 is that commissioner's decision, but it is this commissioner's decision that either the testimony nor the evidence nor the motion to disqualify that was provide adequate argument to force a recusal of the chairman from any of the proceedings, any 8 of the NOAVs that we'll be discussing in the future. So with that, my motion still stands.
Commissioners, if I may, there is a motion that's been seconded on the table to deny KPK's motion as to the 5 NOAVs from which Chairman Robbins has chosen not to voluntarily withdraw. Unless there's further discussion, I'm happy to conduct a vote. All right. All those in favor of Commissioner Messner's motion, please state by saying aye.
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 Any opposed? All right, thank you, commissioners. Thank you for your indulgence in my chairing this discussion. I will turn it back over to the actual chairman right now.
Thank you, commissioners. Okay, with that, I propose that we, as I mentioned earlier, bifurcate and that we amend the final pre-hearing order and that we take up sequentially the following 5 matters. That is UPRR 43 Pan Am G, number 402-523-412, followed by NESU number 1, 402-550-681, followed by NESU Consolidated 402-548-397, followed by Soil Spread Field 402-494-406, and then followed by Jillison number 5, 402-571-143, which I believe are the 5 matters that I believe I can adjudicate. And then I would suggest we do a closing on those 5. Then I suggest you hold the hearing on the remaining 3, in which case I would be recused. And then you could hold your closing on the other 3. Finally, I propose that we provide the parties about 15 minutes to recollect their thoughts so that they can get ready for an opening on the 5 matters that we would take up initially. Does anybody have an objection to this reorientation of the final pre-hearing order or this proposed go forward plan?
Mr. Chair.
Yeah, AG Davenport.
Thank you. Just to be clear, I think what you're proposing is essentially 2 separate hearings.
Right.
Opening party presentations on the NOABs and then closings. And then redoing it, that opening party presentations and then closings on the 3 NOABs which you've chosen to recuse yourself from.
That is correct. Thank you for restating that in a much more elegant manner.
Were you looking for opinions from the commission themselves or also the parties on that proposal?
I'm happy to hear from commissioners as well as parties. We're trying to make a game day call here that given where we are with regard to the motion, we need to move forward. Commissioner Messner?
Thank you, Mr. Chair. I think that that suggestion is a good one. And so I support your proposition. Just a point of clarification, I assume that we're going to take up the hearing officer's recommended order prior to taking up opening statements on the first 5 NOAVs.
Anybody else? All right, I think I'm seeing thumbs up. Mr. Jacobs, Ms. Stafford, do either of you want to opine about this reoriented approach to the next day or so of the first hearing?
I would,
Go
Mr.
ahead.
Chairman. I think that in light of your vote and your recusal from the 3 NOAVs that will be heard second as a separate hearing, it's difficult at this juncture to split opening that way. I prepared an opening statement. I expect Ms. Stafford has as well, because we're about to give them. They refer to many things. There is reference to types of violations, defenses to violations. Taking a few minutes to collect our thoughts and extricate those is a lot harder than it sounds. And I would also point out that we have a time allocation of 15 minutes. Is that now bifurcated for opening statement? these are just the first of my questions regarding how we would implement 2 hearings as indicated by Mr. Davenport as the logical conclusion of your vote. Thank you.
Thank you, Mr. Jacobs. I'm happy to allow you and Ms. Stafford additional time so that you can reorient your opening statement in a manner that it is productive. Would note that had you brought your motion a while back, we would have dealt with this a long time ago. So you've made a little bit of your own bed. Ms. McGowan?
Thank you, Mr. Chair. So unless I'm missing something, I'm not sure that opening statements need to change because all of these commissioners that are on this panel right now, except Chair Robbins, will hear everything that you have to say about all these violations. And so Chair Robbins will be recused from the last 3 that we bifurcate, but all the information that you have should still be relevant for those of us remaining. So does it matter that the opening statement remains the same? Am I making sense? Those of us remaining will still want to hear all of that information.
Yeah. Again, Ms. McGowan, or Commissioner McGowan, I want to honor where we are, which is I will not hear on the last 3, and there will be 2 discrete hearings. I'm perfectly fine allocating 15 minutes for opening on each of the hearings, if that would assist the parties in terms of being able to respond. I'm also happy if it would be helpful to the attorneys in preparing their opening. Do you want an hour to reconvene your thoughts? You tell us what you think is appropriate at this point, given that this is where we're at in this initial hearing.
Chair
Ms.
Robbins,
Stafford?
if I may.
Yes.
Staff is prepared to pivot here. I don't think it will take an extremely long amount of time to reorient our opening statements. And also I would note, particularly for the NOAVs that will be at issue, I think it was both parties' understanding that we would present sort of mini openings at the beginning of each NOAV to reorient the commission to where we currently are. So staff is happy to accommodate whatever the decision of the commissioners is here, and we will be ready to present whenever you are ready for us.
Okay, Mr. Jacobs, do you have a preferred time allocation to reorient your opening?
Yes, I would like the hour that has been offered. Thank you very much. I think we'll need that. While we discussed many openings, the final pre-hearing order does not reflect that. In fact, it departs from the draft final pre-hearing order substantially. In some ways that we discussed with the hearing officer, but in others that we did not. So I'm happy to hear that staff is going to have many openings by NOAV. We had not planned to do so.
My fellow commissioners, are you comfortable if we break for an hour to give Mr. Jacobs and his client the opportunity to reorient? I'm seeing thumbs up. It is 10:18. Let's reconvene at 11:18.
Thank you, Mr. Chairman.
We will stand by at this point. So we'll see you in an hour.
Thank you.
And get started. I see that we have staff's counsel ready. Hello, Mr. Mueller. I see you're here. Is Mr. Jacobs?
I expect him any moment, Commissioner. I will give him a ring if he doesn't jump on right away.
I think I see him.
Good.
There he is. Okay. All right. At this point in time, we have provided the parties with an hour to prepare opening statements. I'd like first to ask Hearings Manager Larson to talk to us a little bit about time with regard to the hearings.
Yes. Thank you, Mr. Chair. So the parties each have 6.5 hours to present their case. The 6.5 hour time allotment does not include opening statements or closing statements. Each party will have 15 minutes for their openings and 15 minutes for their closings. And in light of the oral motion and order that was made this morning to bifurcate the NOAVs, 5 of those NOAVs will be heard with Chair Robbins, and the parties will have 15 minutes for their opening statements and then 15 minutes for closing. And then we would move into the remaining 3 NOAVs that will be heard without Chair Robbins, and the parties will be allowed 15 minutes for opening in those 3 NOAVs and 15 minutes for closing. The 6.5 hours that each party has still remains for all 8 NOAVs. So there's not been any change in the time allotment for the case in chief for all 8 NOAVs.
Great. Thank you, Ms. Larson. And I would note for the record that the hearing officer created an amended final pre-hearing order that was posted within our hearings folder. And the amended final pre-hearing order is consistent with the oral thoughts regarding the new arrangement for the bifurcated hearings. And parties should have a copy of that, as should commissioners at this point in time. And I would then move to opening statements. I see that Council Jacobs has raised his hand. Did you have?
Yes, Mr. Chairman, thank you for recognizing me. I believe we have a housekeeping item related to interim decisions of the hearing officer that has not been addressed before we launch into opening statements, and then the first 5 NOAVs, consistent with your motion and order and the revised final pre-hearing order as you've just described.
What is the housekeeping item that you desire to address, Mr. Jacobs?
There are prior interim decisions of the hearing officer that, as noted during our status conference with hearing officer Peskin and discussed with him and opposing counsel, we might touch upon in the nature of argument, very summary argument, pending your possible adoption of those interim decisions as final orders of this commission. That possibility clearly set forth in the draft final pre-hearing order that was the subject of discussion at the status conference on August 5th, last Thursday. Certainly was something that we reserved the right to spend a little time addressing. It was made clear, and I certainly acknowledge this, that that time, however lengthy or brief, would likely come out of our 6.5 hours total time. And I would be happy if you would allow Ms. Stafford to concur or dispute any of that.
Are you speaking to the motion to continue and to strike, as well as a motion for partial summary judgment, Mr. Jacobs?
I'm speaking to those, as well as the motion regarding our requested discovery that was earlier ruled upon by the hearing officer. I'd like to briefly speak to those to make a record. Thank you.
Ms. Stafford, do you have anything procedural on this issue?
Thank you, Chair Robbins. We do have a few things actually that we are looking for some clarification on as contained in the pre-hearing order. I will first speak to Mr. Jacobs's discussion of the motions. It was also on our understanding that there would be some time allotted before opening statements that would be given to council if they wished to make argument on those interim decisions. It was also our understanding that that time would count against the total presentation time. So staff would appreciate some confirmation on whether that will be the case. I also have a few other items that I have in a list here if perhaps we should discuss the motions item first, and then I can ask my additional questions if that is okay with you.
Okay. Again, I read the final pre-hearing order and I did not see that either of these pieces were a part of that final pre-hearing order. So that is why I was moving toward opening statements. If you received confirmation from the hearing officer that you could raise these procedural matters, I don't have a concern. Ms. Larson, turn the clock on. Jacobs is up. Let's roll.
Commissioners, Chairman Robbins, thank you. I'd like to address the interim decisions of Hearing Officer Peskin in these consolidated proceedings. First, relating to discovery. On July 19th, 2021, the hearing officer issued an order granting in part and denying in part KPK's amended motion for leave to serve written discovery request. In fact, KPK was granted a single request for production and no other written or request for production were permitted. KPK submits that it was not afforded the opportunity to conduct adequate discovery to prepare its defense for hearing, and that this amounts to a denial of due process, especially given the staff's belated expansion of requested relief that was first disclosed on the day discovery requests were due or foreclosed, June 30th of this year. Regarding the order on KPK's motion for partial summary judgment based on the statute of limitations in the Oil and Gas Conservation Act. On August 3rd, 2021, hearing officer Peskin issued an order denying KPK's motion for partial summary judgment, asserting that 6 of the alleged violations against KPK in 3 NOABs are, as a matter of law, time barred by the statute of limitations, CRS section 346115. These include NOABs, these include 3 NOABs, let's leave it at that, which were served more than a year after the violations occurred. Despite this, the staff calculated and assessed penalties from the date of the alleged violations at issue without regard to the fact that the NOAB itself is barred by CRS 346115 for lack of timely service, i.e. for failure to serve the NOAB within 1 year of the occurrence of the seminal violation. In the order, the hearing officer found that the existence of disputed issues of material fact between the parties precluded the entry of summary judgment, which simply means that these factual issues could not be determined prior to this OFB hearing. Importantly, the hearing officer's order did not rule on the merits of KPK's statute of limitations defenses, which means that KPK can and will advance these statute of limitation arguments at the hearings in this proceeding. And the commission can and should decide that the statute of limitations precludes a finding of liability and any associated penalties or other sanctions for the 6 alleged violations in the 3 NOABs subject to that defense, even if it adopts the interim decision denying KPK's motion for partial summary judgment due to the asserted existence of disputed material facts prior to hearing. Those disputed facts can be established at hearing, subject to your findings, of course. Then finally, with regard to the motion to strike or continue hearing, with respect to our expedited motion to strike or continue hearing, we strongly disagree with the August 4th, last Wednesday, ruling of the hearing officer in his interim decision as lacking a legal basis, and we urge you to strike the expanded relief sought by staff from the second amended notice and application for consolidated hearing. In the original and amended notices, between December of last year and April of this year, the staff requested relief for findings and rule violations and assessments of civil penalties. Those did not include a pattern of violation or knowing and willful violation allegations or the sanctions that might follow from them, suspending certificates of clearance and the inability to obtain new permits from this commission. That was not raised until June 30 as proposed, not entered as an actual notice that could be stricken until July 9th over the signature of the secretary, and therefore it was untimely. On July 9th, the hearing officer e-filed that signed second amended notice. KPK conferred with staff counsel 14 days later, seeking withdrawal of the second amended notice, or at least of the expansion of requested relief, and noting that it would move to strike in the absence of such withdrawal. Counsel for the commission acknowledged that it would not withdraw and it would oppose such a motion to strike that, and a motion was filed on July 26th. In his order, the hearing officer agreed with KPK that this constituted an amendment to the original relief requested by staff, and that staff's argument to the contrary was without merit. And such amendment was material. Material amendment of a notice requires 60 days prior notice per specific commission rule. The only thing the hearing officer actually decided in declining to grant the motion to strike was that KPK, on some theory or in his discretion, failed to timely object to staff's second amended notice. However, in acknowledgement that the amendments to the notice were in fact material, the hearing officer decided that the issue of whether or not we had committed a pattern of violations or knowing and willful violations will be bifurcated from the current hearing without specific legal support for doing so. But this does not cure staff's transgression and the prejudice to KPK of this interim decision. It just kicks the can down the road. We don't know how long, without discovery, without hearing officer supervision over pre-hearing procedures, etc. We contend that the order lacks legal support. There is no commission rule establishing that this is untimely 14 days after the notice issued in final form. And even reverting to the rules of civil procedure, KPK has 21 days to respond to a filing under CRCP. That is unassailable. Therefore, the issue is not ripe for dispute until the proposed notice became an actual final notice issued by the hearing officer over the secretary's signature and e-filing it. Copying KPK with a proposed notice by email or even emailing or e-filing the unsigned notice does not, a notice that does not mention pattern of violation or willful and knowing violations is not conferring regarding a material amendment, and so conferral also did not occur. For these reasons, the commission should not adopt the hearing officer's interim decision order and should instead grant KPK's motion to strike the materially expanded request for relief on pattern of violation and knowing and willful violations. If the commission would benefit from any more detailed oral argument beyond these high-level points, outside of our allotted 6.5 hours at this hearing, we would welcome the opportunity. Thank you for that opportunity. Mr. Chairman, I believe you're muted.
Sorry. Thank you, Mr. Jacobs. Ms. Stafford, if you would like to respond at all to the legal arguments Mr. Jacobs just made, you now have an opportunity to do so.
Thank you, Chair Robbins. I would like to note at the outset that staff will rest on its pleadings with respect to the discovery order and the motion to strike. With respect to KPK's argument on the partial summary judgment motion, specifically related to their statute of limitation claims, essentially what KPK is arguing here is that the claim accrued 1 year prior to the issuance of the NOAVs in these 3 NOAVs they challenge and the 6 violations that they are concerned with. While this violation might have been discovered more than a year prior to the NOAV, it's staff's position that the violation didn't run or accrue until the last occurrence of the wrongful act. As an example here, say staff was asserting that a sign was not posted at a particular tank battery. Staff notices this during an inspection on I'm just going, like I said, I'm giving you an example here. On December 20th, 2018, staff inspects again months later, and still there's no sign present. So an NOAV is issued further down the road. In my example here, let's say it's issued January 1st, 2020, more than a year after it was first discovered. But staff has documentation that showing that the sign wasn't posted until December 25th, 2019. In this case, the violation continued by a few days into the statute of limitations period. In enforcing the NOAV, staff would apply the statute of limitations as a cap, meaning staff would only pursue the penalty amount that fell within the statute of limitations period. So in my example, where I have said to you that a violation was discovered on a particular day and it was not corrected until more than a year or so later, staff would only pursue the days of penalty that fell within the statute of limitations period. And what we're saying here in our argument that was included in our response is that the violations for which KPK is asserting are time barred actually continued into the statute of limitations period. Staff appropriately recalculated a penalty where we found that was the issue. We were endeavoring to make sure that each calculation lined up with the statute of limitations provided for in the Act. So I guess in essence, we disagree with KPK's interpretation of the statute of limitations and the continuing violations doctrine as they set forth in their motion regarding partial summary judgment. And we would ask that the hearing officer's recommended order, interim decision, we would ask that that remain in place and that the commission not overturn those. Thank you.
Thank you, Ms. Stafford. Okay, fellow commissioners, we've heard oral argument on the three motions. We have three orders of the hearing officer, one on each motion. I, as one commissioner, am not inclined to change the orders from the hearings officer. With regard to the motion to strike or continue, we have bifurcated the issues of pattern of violation to a separate hearing date. I think that is appropriate. I am not inclined to reconsider the request for production. And with regard to the motion for partial summary judgment, I think Mr. Jacobs and his client absolutely have the right to argue that issue on the merits. I believe that the hearing officer correctly found facts in dispute, and we are going to uncover those facts during these hearings, and we will then need to weigh that defense at the appropriate time. That's my inclination. Does anybody have an inclination to do something different? Otherwise, we can move to next procedural steps from either side. Okay, seeing no further discussion, I believe that that is a answer on those issues. Mr. Jacobs, did you have anything further procedurally before we allow Ms. Stafford to run through her list of other procedural matters?
Thank you, Mr. Chairman. Yes, I do have one additional item, and I'll be interested to hear what Ms. Stafford also raises. I might chime in on those. As Ms. Stafford knows, and the hearings manager knows, we have an exhibit that contains confidential business information. And we e-filed a redacted version of that exhibit, prominently labeled as redacted. And then we submitted to Ms. Stafford and to the hearing officer only, and no one else, an unredacted version of the exhibit, proposed exhibit. It's an expert report that is the basis for expert testimony that will be heard later in these proceedings. And that is unredacted, and it is clearly labeled. Unredacted version contains confidential business information on every single page. Should the commission wish to question our expert witness on specifics of the unredacted version. I am curious as to how that would proceed and whether this hearing would be closed to the public for that purpose, similar to an in-camera review of confidential and potentially privileged information in a court of law. That is my question.
Thank you, Mr. Jacobs. I'm curious as well. As you know, we are a formal public body and all proceedings need to take place under the open meetings law in public unless it is qualifies for an executive session matter. And I'm going to give AAG Davenport a little time to sort of think about that. And I, for one, and I think my fellow commissioners as well, we'll figure that out and cross that bridge when and if we get to it. It may be that we don't have questions and then we don't need to cross the bridge. But if we do need to cross the bridge, we'll make sure we do so in a manner that accommodates the concern that you raise. Is that fair enough at this point?
Thank you. And that was the thinking behind raising it now. We don't intend to introduce that redacted exhibit and cause some of you to perhaps want to review the unredacted exhibit and have questions posed for a couple of days.
Very good. If that concludes your list, we'll turn to Ms. Stafford and see what her procedural list is, and we'll certainly give you a chance to respond. And in like mine, Ms. Stafford, if you want to respond to the confidential business information piece, do so first, and then we can go to your list.
Thank you, Chair Robbins. I don't think we have a response to the confidential business information exhibit. We acknowledge we had discussions with Mr. Jacobs about that, and I think we can leave it there. With respect to the list that I have, would it be easier for you if I listed out all the questions at once, or should we take them one by one? They're not a lot. I'm sorry.
Yeah, let's take them one by one. That might be easier.
Okay. So with respect to the pre-hearing order, sets forth that a discussion on penalty will occur following any potential findings of violation. Staff is just looking for a little more clarity on when exactly this will be happening. Will this be a point of discussion during each NOAV or a global discussion after violations might be found after the NOAVs? I believe the pre-hearing order is a little less than clear about that, so we wanted to ensure that we were prepared to present accordingly. And this sort of relates to also the discussion of pattern of violations. If we could get some more clarity on when that might be calendared, that would be helpful as well.
Thank you, Ms. Stafford. As chair, my preference is that we hear each of the violations in order. So the first 5 in the first hearing, and then at the end of the hearing, we would deliberate sequentially, go back to the first one and then the second one and then the third one. I'm looking at my fellow commissioners. I also think that we may want to hear the evidence on the first NOAV, and then the commission will determine, do we want to hear the second one before we start deliberating? I don't think we have an answer to your question, frankly. And we're going to play it by ear if that's okay. And you should know after the first NOAV is after you've rested, the 5 of us will look at each other and make a determination of, okay, now do we want to go to the second NOAV without deliberating, or do we want to deliberate whether there's a violation, and then if so, whether there's a penalty? This is our first hearing, and so we are going to determine those sorts of procedural issues as we go.
Thank you, Chair Robbins. And if I could possibly clarify my question,
go ahead.
Just to help out. So I think what we're asking here is whether the presentation on any calculation of penalty should be included as we're discussing whether or not there is liability on a particular violation.
Yes.
Thank you.
At least that's my opinion. And I'm not seeing any commissioner nodding their head otherwise, so that will be our answer.
Thank you for that. The next, I'm sorry, if Mr. Jacobs would like to respond, I don't want to move on without that.
I think that works well with our planning with respect to each of the NOAVs and the two portions of hearings or two hearings to be conducted, summarizing penalty at the end of the testimony on the existence of violations, the evidence supporting or refuting a violation. So I'm okay with that.
Okay, so I think we're all on the same page. Let me segue to the next point that I'm going to raise sua sponte on my own, which is we have reserved a third hearing on the pattern of violation through the pre-hearing order. And so once we're done with these two hearings, and if there is a finding of violation, and if there is a finding of penalty associated with that violation, we do not want you to argue or deal with the pattern of violation or mitigating or other, all of that stuff. So as I anticipated, we would have a sort of an interim, not final order, and then we would have the pattern of violation hearing, which may adjust that order, and then there would be a final order entered, assuming violations are found. So I just want to sort of clear that out, make sure we're all on the same page on that front too.
Thank you, Chair Robbins. I believe we are.
Mr. Jacobs, thumbs up.
I'm clear as to what you said. I'm at a loss for the third bifurcated portion of this, the pattern of violation and willful violation and other sanctions being heard possibly soon and possibly without opportunity for information exchange and discovery as would be afforded us had the notice been amended sooner and in compliance with the Commission's own rules.
Let's deal with that issue, Mr. Jacobs, once we get through the hearings that are scheduled for this week. And that might be something that you address with the hearings officer. It might be something you address with this commission, but let's try to keep moving if we can today.
That's fine. I'm just trying to respond as genuinely as I can. I think as far as you've gone, I'm okay with what you outlined, Mr. Chairman. But I need to remind you of the uncertainty of the bifurcation of pattern and knowing and willful and the sanctions that staff seeks, and our inability to obtain any discovery with respect to that by virtue of the interim decision that you I think, adopted or will adopt based on the argument that you heard.
Understood. Thank you.
Thank you.
Ms. Stafford, do you want to go to your next issue?
Yeah, thank you, Chair Robbins. Circling back to something we brought up right before our break about the mini openings that we were envisioning to occur as each NOAV is addressed. Is that something that the Commission would like to hear? We believe it will be for your benefit to sort of reorient you as we present the next grouping of evidence on the next NOAV at issue.
So you both are planning the 15-minute global opening, right, for each of the two bifurcated hearings. And so you're suggesting, Ms. Stafford, a second mini opening per NOAV?
I am, possibly 2 to 5 minutes just to reorient you on what we plan to present in that particular NOAV, since it is our burden to prove these particular violations.
I'm comfortable with that. I think it might reorient us on the specific NOAV. Ms. Larson, would that 2 to 5 minutes count against each party's time?
Yes, Mr. Chair, it's contemplated by the pre-hearing order that it would count against each party's time.
Okay, I'm good with it. Looking to fellow commissioners if anybody has a concern. Not seeing any. Mr. Jacobs, recognize you.
My only concern was that it comes out of the 6.5 hours. I think that staff can use that time if they want to orient with a mini opening. Likewise, we may review penalty at the conclusion in a sort of mini closing by NOAV, and that'll come out of our 6.5 hours.
Okay, so let's plan on you each having the discretion to do that. And if you do, it comes out of your allocated 6.5 hours.
Thank you. That's fine.
Thank you, Chair Robbins.
Anything else, Ms. Stafford?
Yes, and then the last thing I would like to bring up is with respect to the exhibits in this proceeding. Yesterday, Council for KPK and Council for Staff had a discussion, and based on our discussions yesterday, we believe we're in agreement to authenticate and admit all of the exhibits that do not have any objections attached to them at this time. If Mr. Jacobs would like to correct me, I am more than happy to have him do that, but that was our understanding of our discussion yesterday in order to make more use of our time.
Mr. Jacobs, are you good with that?
I am, but we had also proposed and not heard back from staff counsel regarding a stipulation as to the admissibility or admission of exhibits for which only a foundation objection had been raised and no other. And if staff could respond to that, we might further simplify disputes or minimize disputes over admissibility of certain exhibits subject only to prior foundation objections.
Ms. Stafford?
Thank you, Chair Robbins. We did receive that proposal, but we had also set forth an additional proposal, which was that in the interest of efficiency, staff was also willing to agree to the authentication and admittance of all the exhibits that were listed in this matter if KPK also agrees. So I think we had come to an impasse in that particular area. So I think that was the reason that we did not provide the response yesterday to them.
Mr. Jacobs, did you have a response to that point?
Yes. KPK is not prepared to waive its objections other than foundation to certain exhibits in the interests of efficiency and certainly not in the interests of due process and fairness. Thank you.
Okay, Ms. Stafford, is your perspective still that you would not want to waive foundation objections?
No, well, I'll clarify, Chair Robbins. We are willing to waive the foundation objections and agree that those exhibits can be admitted without the necessary foundation. If KPK is not willing to agree to the admittance and authenticity of all the exhibits, then that is okay too.
Okay, so I think where we are is we will admit all exhibits that are not objected to, 1, and 2, we will admit all exhibits that only have a foundation-only objection. Is that accurate?
That is my
I believe so, Chair.
That is my understanding as well. Thank you, Mr. Chair.
From either side?
Yeah, and that's from either side.
From either side, yes.
Foundation,
Yeah.
Basically, foundation objections have now been withdrawn, and all exhibits that are agreed to are admitted and are authenticated.
If I might clarify, I just want to be careful. It's the foundation only objections that are withdrawn.
Yes.
There may be associated with other exhibits for which there are other objections, also a foundation objection. I'd have to confirm that. So I don't want you to have the impression that this is an overbroad agreement to admissibility of exhibits. I'm happy to check that over the lunch hour and confirm that when we resume after the lunch break, if that would be acceptable.
Yeah, that's fine. I recall there are some exhibits that have multiple objections, one of which is foundation. Those exhibits are not admitted, but if an exhibit is only had a foundation objection, it is now admitted, as are all exhibits that are not objected to.
Correct.
Okay.
Thank you, Mr. Chairman.
Thank you, Chair Robbins.
Anything further from either side?
Not at this time, Chair Robbins, from staff.
Not from KPK. Thank you.
Thank you both. Okay. Anything further before we move into opening statements? Very good. I believe at this time, we will hear from staff an opening statement of 15 minutes or less, which will not be attributed to staff's 6.5 hours.
Thank you, Chair Robbins. I am just pulling up our quick opening presentation.
Ms. Stafford, as you're pulling that up, hold on just a sec. Ms. Amaro, for the screen, can we get rid of the participants piece over on the side? That way everybody's a little bit bigger. Is that, yeah, close that. Yeah. At least on my computer, I like it better that way. Is that okay? Okay, Ms. Stafford, you are good to go. Ms. Amaro, you might enlarge that and make it full screen. There you go. All right, thanks.
Commissioners, can you see my screen okay?
We can see your screen, yes.
Great, thank you very much. Good morning, Commissioners. I am Caitlin Stafford, Assistant Attorney General and Counsel for Commission Staff, and docket number 2011-002661 et al., regarding alleged violations of COGCC rules and regulations by KP Kaufman Company, Incorporated. I'd also like to introduce my co-counsel in this matter, Kelly Rosenberg, COGCC Enforcement Officer. This portion of the hearing is comprised of 5 notices of alleged violation, or NOAVs, alleging multiple violations of several distinct Commission rules, which I will describe as we go forward here. Notably, the Commission rules at issue here are the rules that were in place prior to January 15th of this year. We're not even talking about the Commission's current rules. Now, we heard a little bit in our preliminary discussions about how we got here, but I am here to tell you about why we are here. Commissioners, this is a case about an oil and gas operator that consistently fails to comply with the Commission's rules. In the 5 NOAVs before you, staff has alleged a variety of rule violations, from improper disposal of hydrocarbon-impacted soils to failures to comply with staff directives meant to ensure that KPK's operations are protective to the environment, to a failure to take reasonable precautions during an uncontrolled active gas release to prevent significant adverse environmental impacts. Each NOAV tells a similar story of deadlines that pass, corrective action due dates that are not met or otherwise complied with, and the actual or threatened impacts that follow. For many of the violations alleged, KPK has already stipulated to the underlying facts. Through evidence and testimony, staff will prove the rest. And after the presentations are completed, the record will support a finding that KPK is and has been unable to operate in the state of Colorado in a manner protective of public health, safety, welfare, the environment, and wildlife resources. Commissioners, this case is straightforward. Through the actions as alleged in this case, KPK has shown itself to be an operator that is unreliable, incapable, and impactful. Unreliable because KPK cannot meet deadlines or approved timelines. Incapable because KPK cannot fulfill its obligations to the COGCC. And impactful because KPK cannot timely and adequately clean up its messes. Now, in the first NOAV you'll hear about, the UPRR 43 Pan-Am-G consolidation flow line, or near-miss matter, you will learn about an active gas release observed by environmental staff. KPK learned of a flow line release on September 19th, 2020. When staff went out to inspect the spill cleanup efforts 4 days later, staff observed an open, unsecured excavation on the north side of Weld County Road 4. The excavation contained an exposed flow line, and no KPK personnel were present when staff arrived. At that point, staff heard gas hissing from a hole in the flow line, saw pooled liquid hydrocarbons in the excavation, and immediately notified KPK to send someone out to address it. When KPK personnel arrived, Some crew members approached the north side excavation, while others approached a separate open excavation about 25 yards to the south on the other side of Weld County Road 4 to begin a different flow line repair. At that point, staff required KPK to stop work because staff was concerned of the imminent health and safety impacts resulting from the active gas leak on the flow line on the north side of the road. Here, it was eventually determined that the gas leak occurred due to an improperly functioning isolation valve. Waters of the state, residences, and other occupied structures, and the county road were either impacted or threatened by the gas release. In this near-miss matter, staff has alleged 6 separate violations of Commission's rules. In the second NOAV, you'll learn about the NESU number 1 matter. According to KPK, it was notified of a spill of produced water and condensate from the NESU 1 flow line by the landowner in the fall of 2019. The spill occurred while the landowner was irrigating his cropland. Following notification to the agency, staff required KPK to clean up and close out the spill or provide a remediation work plan. KPK proved incapable of meeting this requirement, submitting a remediation work plan almost 2 months after it was requested and submitting an implementation schedule 2 months after that. In the meantime, the agency received a complaint from the landowner detailing significant concerns with the progress of the work being done to clean up the spill. The complaint specifically alleged that the earthen berms meant to contain excavated impacted soils from the spill had been breached, posing a significant threat of impact to the environment. Staff documented these issues in ensuing inspection reports, requiring KPK to address these site conditions. KPK demonstrated it was incapable of meeting these deadlines, and the violations at issue were only remedied when KPK hauled hundreds of dump truck loads of impacted soil to an unauthorized landfill, the subject of another NOAV you will hear about during this hearing. In this matter, staff has alleged violations of 2 separate Commission rules. In the third NOAV, the NESU consolidated matter, located in the same general vicinity of NESU number 1 as seen here on this map, you will hear a similar story: a spill of hydrocarbon liquids, a farmer landowner notifying KPK of the spill, blown reporting deadlines, and incomplete documentation. By the time the complainant notified staff of the spill, it had been approximately 9 weeks since the spill occurred, and KPK provided no notice to the agency in that time period. Following staff's inspection of the spill, KPK was required to do a subsurface investigation in an effort to figure out the spill's impacts and determine a spill volume. KPK proved incapable of meeting this deadline and had to be reminded to submit this information at a follow-up inspection a month after the information was due to staff. KPK's actions made it extremely difficult for staff to identify the true, actual, or threatened impacts at the site. In this matter, staff has alleged violations of 2 separate Commission rules. In the fourth NOAV at issue here, the soil spread field matter, staff will show that KPK took hundreds of dump truck loads of hydrocarbon impacted soil from the NESU number 1 location and dumped it in a 2-acre field area north of KPK's offices in Weld County. Staff was unaware of KPK's activities until it received an anonymous complaint on June 25, 2020, alleging that exploration and production wastes were being dumped in the field. When staff inspected the location in the ensuing days, the presence of oily waste was unmistakable because staff smelled hydrocarbon odors and saw hydrocarbon staining on soils at the location. Instead of dumping this waste at an approved landfill, KPK ignored potential environmental impacts and dumped the oily waste at a location that it has already stipulated is located within 100 yards of a freshwater pond and less than 400 feet from mapped wetlands. In this matter, staff has alleged violations of 4 separate Commission rules. And finally, in the 5th and last NOAV before you at this stage, you will learn about the Gilson number 5 flow line. Like some of the other NOAVs we discussed, this is another situation where a landowner had to file a complaint with the agency in order to get the spill on COGCC's radar. Here, the complaint regarding a leaking gas flow line on the complainant's property was reported to staff in October 2020. Upon further investigation at the site the next day, staff determined that the spill had actually occurred back in July 2020. Yet KPK provided no notice to the agency and did not provide COGCC with the appropriate documentation to delineate the actual or threatened impacts from the spill. Were it not for the landowner losing patience with KPK's inability to communicate its plans for the open excavation on the landowner's property, the agency would not have learned of the spill. In this matter, staff has alleged violations of 2 separate commission rules. Throughout the course of this hearing, you will hear from staff witnesses with firsthand experiences at each location. You will see exhibits that document their observations at each site. And as I've mentioned, KPK has already stipulated to a large majority of the facts underlying each alleged violation. KPK may try to make this case seem more complicated, but it's really not. And it's staff's burden to prove by a preponderance of the evidence, or more likely than not, that KPK should be found in violation of each rule as alleged in each NOAV. In the end, the testimony and evidence in the record will show that KPK is an unreliable, incapable, and impactful operator. Staff asks that you find KPK in violation of the Commission's rules as alleged, impose staff's requested penalty as set forth in the claims table attached to its pre-hearing statement, and order any other necessary and appropriate relief. Thank you.
Thank you, Ms. Stafford. Yeah, let's unshare your screen, and we will give Mr. Jacobs an opportunity to get ready for his 15-minute or less opening statement.
Ready when you are, Mr. Chair.
We're ready to go.
Thank you. Commissioners, KPK is a family-owned oil and gas producer and field services provider for over 37 years, with myriad wells and associated operations in Weld County and elsewhere. It presently employs 150 individuals, a few of whom you will meet in the coming days. As you will hear, conducting business in a depressed market, managing operations in the middle of a worldwide pandemic, adjusting not just to a new set of regulations, but to a new enforcement philosophy, has posed major challenges for the industry and for KPK. No operator is perfect. KPK is not perfect. But it is evident at just a glance that staff has pulled out all the stops with regard to the allegations and penalties proposed in this proceeding. And if it is staff's intention to send a message to the industry and make an example of KPK, still that message needs to be tempered. It needs to be reasonable. It needs to be measured. And as you will see in many different ways, that has not happened. Commissioners, this order finding violation hearing concerns alleged violations in 5 notices of violation, NOAVs, that KPK vigorously disputes in numerous significant respects, ranging from violations that are time barred by the expiration of the statute of limitations and excessive to the lack of violations outright, to the mischaracterization of violations and excessive calculation of penalties sought by staff well in excess of historic penalty assessments for KPK and other operators for comparable violations. We urge you to remember the dictates of your own Rule 514 to ensure that the Commission's decisions are free from personal bias and that its decision-making processes are consistent with the concept of fundamental fairness as you listen to the evidence and testimony during this hearing, being mindful that staff does indeed bear the burden of proof. Regarding KPK's statute of limitations defenses, it is unassailable that the General Assembly created a 1-year statute of limitations in the Oil and Gas Conservation Act. Staff will argue that by rule they can calculate penalties for every day of an alleged violation, including for days a requested form is filed late. And while this may hold on certain facts for the calculation of penalties, it cannot be properly read to render the statutory limitations period meaningless. The NOAVs at issue in this bifurcated OFB hearing, 402-550-681 NESU 1 flow line and 402-548-397 NESU consolidated flow line, were served more than a year after the seminal violations occurred. Staff has admitted this in penalty calculations provided to KPK, not claimed as confidential settlement communications or otherwise labeled as such at the time they were transmitted to us. And this will also be established through witness testimony and on cross-examination. You must honor the dictates of the legislature and dismiss these NOAVs as time-barred. For one of these sites, you will also hear testimony, expert opinion, and review exhibits regarding the existence of historic contamination for which staff has not and cannot establish that KPK is the responsible party. And yet KPK has expended significant efforts and resources in a very difficult commodity price environment, and most recently during a global pandemic, which significantly affected its ability to keep work in the field progressing. Despite its protection of environmental compliance and remediation functions from the effects of belt tightening across other parts of the company. Sites with historic contamination that KPK has diligently addressed through its remediation efforts, or one site, is the NESU 1 flow line location, NOAV 402-550-681. Indeed, you will hear testimony and expert opinion that the historic contamination at NESU 1 flow line was several times greater in volume of impacted soil than a recent small release, which led to the discovery of the historic contamination there. Contamination that is likely a decade old or older, but that line has been owned and operated by KPK for less than 2 years. And if you should find a violation at this location on facts found after hearing, justice and fair dealing require that any penalty be adjusted to account for the expense of addressing historic contamination not proven or provable to be the result of KPK's operations. To do otherwise would convert the Oil and Gas Conservation Act into a strict liability statute. In addition to these significant defenses of statute of limitations and not being the responsible party for historic contamination at the NESU number 1 flow line location, KPK disputes alleged violations at a number of locations. For example, a release at the NESU consolidated flow line location, NOAV 402-548-397, involved a release from a flow line serving a low producing well estimated at less than 1 barrel per day in a dry cornfield with no proximity to surface waters or public byways. But because staff asserts that the field was irrigated, they allege impacts to waters of the state, which if true, would make the release reportable. In fact, that release by all accounts occurred on November 1st, 2019, when irrigation was not even possible and field conditions were dry, as you will hear from KPK witnesses. Still other violations, though minor in nature, are the subject of huge penalties proposed due to compound violations that can and should be consolidated under the staff's own penalty policy, such as failure to report an incident in 24 hours, and again in 72 hours, and yet again in 10 days, all for the same alleged failure to report an incident that is disputed whether it's even subject to reporting. These approaches to penalty calculation produce highly exaggerated fines, which greatly exceed penalties assessed historically for similar violations. And on top of these huge penalties in this consolidated proceeding, staff has sought to add a multiplier based on the alleged pattern of violation and knowing and willful behavior, as well as other severe non-penalty sanctions. This was not done in a timely fashion, adding this relief, and the hearing officer simply directed that such allegations be heard at a later date. We contend that due to staff's violation of the commission's own rules and associated lack of timeliness in materially amending the second amended notice and application for hearing, these allegations may not be heard at all. But the larger point is that for you and in this portion of the OFB hearing, the larger point is that staff seeks extraordinary relief against this operator that is grossly out of proportion to the alleged infractions. And there is There are more common alleged violations that simply suffer from a lack of evidence demonstrating an actual violation. The adherence to stormwater BMPs for excavated soils and the use of temporary fencing for safety to prevent entry to an excavation area are examples common to several NOAVs. The evidence and testimony will show that berms and temporary fencing not completely in place during ongoing excavation, even during inspections when photos may have been taken, were regularly replaced at the end of active work, and staff has no evidence to the contrary. Staff's allegations of inadequate BMPs or inadequate fencing are therefore vague and lack support in a specific rule requirement. Moreover, perhaps because staff is compelled to seek maximum penalties by virtue of its improper expansion of requested relief in the second amended notice, it fails to toll assertedly continuing violations, even for failure to submit forms, and even while KPK is waiting for staff to review and respond to requests for closure or for permission to backfill, for example. Likewise, even when access was denied KPK to perform required work to make corrective actions and satisfy conditions of approval, staff has failed to toll days of alleged violation in its calculation of proposed penalties. That is how staff is able to cobble together almost $3.5 million in penalties, even without regard to whether a pattern of violation or knowing and willful violations can be shown. It is your obligation to right size and equitably adjust these excessive proposed penalties consistent with the penalty policy and all notions of consistency and fairness in the administration of the Oil and Gas Conservation Act. Finally, you will hear evidence concerning KPK's ability to pay such an excessive penalty as sought by staff, a recognized mitigating factor in the Commission's own penalty policy and virtually every environmental regulatory civil penalty policy at the state and federal level. That evidence, based on confidential business information provided to KPK's expert forensic accountant, supports his opinion that KPK cannot pay anywhere near the $3.5 million or more sought by staff, and you must therefore adjust the penalty for any violations that you may find beyond the percentage reductions provided in the penalty policy otherwise, because putting companies out of business is not deterrence. It is an abuse of penalty authority afforded to the Commission by the legislature under the Act. And there is plenty of precedent for such ability to pay adjustments in prior Commission orders and AOCs, and certainly in prior EPA and CDPHE settlements under their very similar penalty policies. These are examples of the type of excess engaged in by staff in their pursuit of enforcement against KPK, a proud family-owned oil and gas producer and field services provider. You will hear evidence and testimony regarding still other hotly contested allegations and proposed penalties as well. Please pay close attention to the evidence and testimony because much is at stake. Staff bears the burden of establishing violations by a preponderance, may not compound violations unreasonably to maximize penalties, must toll days of violation equitably, and consider an operator's ability to pay so as to enable it to return to compliance, especially in these extremely challenging times. Because staff has failed to do so, you must step in to ensure fairness and consistency in the administration of the Act. Thank you.
Thank you, Mr. Jacobs. I'm now looking to fellow commissioners. It is 12:20 on our agenda. We had scheduled at this time a 45-minute break for lunch. I suggest perhaps we do that, even though we had an unanticipated 1-hour break this morning. It's still lunchtime. So do you want to potentially come back at 1:05 and take our scheduled break? I'm sorry, 1 o'clock? 1 o'clock. Okay, we'll come back at 1 o'clock. Ms. Stafford, we would then look to you for your case in chief on the first NOAV.
Thank you, Chair Robbins. We'll be prepared.
Thank you both for your presentations and opening statement. We'll see you soon.
Thank you.
Commissioners, can you hear me? Okay, we're having audio difficulty. Bear with me for a sec. If everybody could hold tight, we're trying to figure out the video and the audio.
Thank you.
Okay, testing, testing. Nod if you can hear me. And you're not hearing two of me. Okay. All right, I think we're back up and running. Evidently, the microphones automatically turn off after a period of time. So we now have them turned back on. This is Colorado Oil and Gas Conservation Commission hearing on August 10th. It is 1:04. We are back from our lunch break, and I believe we are now teed up to hear party presentation on NOAV 4025-23412. I believe Ms. Stafford, the floor is yours.
Thank you, Chair Robbins. I'd like to turn it over to my co-counsel, Kelly Rosenberg.
Good afternoon. And before we get started, I do have one question. My understanding was that witnesses were supposed to have been sworn in together earlier this morning. And I didn't know where we were with that.
AG Davenport.
Thank you, Mr. Chair, and thank you, Ms. Rosenberg, for raising that. Yes, we do need to swear in witnesses. I'm happy to do that however is most efficient. If we want to start with staff's witnesses that will testify in this matter all at once, and then I've never done this via Zoom, so as long as everybody's comfortable with all of the potential witnesses from staff side being unmuted at the same time and repeating after me with their hands raised, we can go that way. If someone could identify the potential witnesses for staff, so Ms. Larson can let them in as panelists, please.
And I'm sorry if I misunderstood. You mean for this matter specifically or all of the matters?
Let's do all of staff's witnesses at the same time.
All right.
Thanks, AG Davenport. According to the amended final pre-hearing order, our witnesses are, our potential witnesses, I should say, are Carrie Brown, Chris Canfield, Dr. Peter Gintatis, Nikki Graber, Joe McLaren, and I'm sorry if I'm going too fast, Ms. Larson, please let me know.
Yeah, why don't we, Ms. Larson, do you want to get each one and then she can call the next one? Hold on just a second, Ms. Rosenberg.
All right, Ms. Rosenberg, thank you. So we are bringing in Carrie Brown. We're bringing in Dr. Peter Gintatis. We're bringing in Chris Canfield. And then the rest of your witnesses, please.
Sure, we have Nikki Graber.
All right.
Joe McLaren.
Yes.
Rob Young.
All right.
John Axelson.
All right.
Mark Schlegenhoff.
And
the final two on my list, Jeremy Farron and Julie Murphy, are currently panelists already. We did want to let you know that Kim Schur, who we had listed as a May call witness, he's actually unavailable to be with us, so he will not be joining for this swearing in, and at this time we're not anticipating calling him.
thank you.
Mr. Chair, it's acceptable if I go ahead.
Yeah, although, are we going to get double down effect if everybody's speaking at the same time?
So I was going to suggest that we go one at a time. I will call a possible witness's name and then have that witness raise their right hand and state as follows: I, whatever your name is, swear to tell the truth. That's all you need to do. And then we'll go on to the next person. I'll call the next person's name. I will just go in the order that you appear on my screen. I don't know that it's the order that you appear on your screen, but I'll call names out so you'll know what to do. And again, all I'm asking you to do is to raise your right hand and say, I, state your name, swear to tell the truth, and we'll go on to the next person. So I'd like to start with Dr. Gintatis, please.
I, Peter Gintatis, swear to tell the truth.
Thank you. Jeremy Farron.
I, Jeremy Farron, swear to tell the truth.
Thank you. Nikki Graber.
I, Nikki Graber, swear to tell the truth.
Thank you. John Axelson.
I, John Axelson, swear to tell the truth.
Rob Young.
I, Rob Young, swear to tell the truth.
Thank you. Director Murphy.
I, Julie Murphy, swear to tell the truth.
Thank you. Carrie Brown.
I, Kari Brown, swear to tell the truth.
Kari, my apologies. Chris Canfield.
I, Chris Canfield, swear to tell the truth.
Thank you, Chris. Joe McLaurin. You're muted, Mr. McLaurin.
I, Joe McLaren, swear to tell the truth.
All right. Thank you, witnesses. Ms. Rosenberg, is that everyone? Ms. AAG Stafford, is that everyone?
Yes, AAG Davenport, I believe that's everyone for staff. Thank you.
Okay. The witnesses who've just sworn to tell the truth, you should consider yourself under oath for the entire pendency of the hearing this week. I do not intend to re-swear in witnesses every time they may be called back up to answer a question or we switch from direct to cross-examination, anything like that. So that swearing in will count for, and you should consider yourself under oath for the entirety of this hearing this week.
And we'll do the same thing with the Mr. Jacobs's witnesses when we get to him. Is that right?
That's accurate. The first time KPK calls witnesses, we'll do the same thing.
Mr. Jacobs, is that acceptable?
We have our witnesses assembled for purposes of swearing in now, if that would be convenient.
Let's do it. Let's rock and roll. Yeah. Why don't you tally them off one at a time and give it in a pace that Ms. Larson is able to pick them up.
We have our witnesses here at our offices. A number of them are together. There will be a couple of them that are remote. And I would ask that my colleague, Lucas Satterley, unmute and perhaps assist me with those that we have in a conference room. They'll all be available or together on webcam for swearing in. And then a couple of individuals, I believe, are Zooming in from remote, and you should have them. But I'll run down the list. Excuse me. So hearings manager Larson, the ones that I'm going to state for our witnesses in the final pre-hearing order that don't appear in Zoom are here at our offices. I don't think they've logged in on personal devices.
And Mr. Jacobs, sorry to interrupt. If you could just let us know the individuals who we do need to bring in via Zoom, and we can move those folks in now. And then I understand that your associate will have the other individuals in the office, and we will ensure that they're on camera when it's time to swear them in.
Sure. So present here, and I don't think logged in separately via Zoom. Actually, yeah, that's correct. Is Mike Hattel. We will not be swearing in or calling Jeffrey Kaufman or Kevin Kaufman at present. Max Knopf is here. Avi Mailer is here. Jeff Peterson is here. Manuel Silva is here. I believe he's listed twice in the pre-hearing order, so you can strike him a second time. Point of order, Ms. Larson. Our conference room needs to be admitted as a panelist so that the webcam will show all of the assembled witnesses here.
And what is that? What is the name that conference room is coming in on the meeting? Do you know?
Or is it a phone number?
Or, yeah. Well, hopefully it's a.
E. Lee Witness. That's P. Lee for Pamela Lee, our paralegal.
Got it.
She set up the camera feed of the hearing in that conference room.
There's a whole bunch of P-Lees.
There are.
Is there a P. Lee witness that's unique?
There's not. We have 4 P. Lees.
I apologize. Maybe.
Why don't you have your paralegal chat or raise your hand?
That's fine. If Pamela, you can raise your hand from the feed that you're getting in conference room 329, then Ms. Larson will see which P. Lee to admit as a panelist. I believe that's correct.
That is correct.
Thank you. And I can affirm also that Richard Stoltz is here remotely, and you've already admitted him. Greg Weiss will be logging in remotely, and you need to admit him. We do not intend to swear in Mr. Batala or Mr. Harrison or to call them, or Mr. Weimer, Miles Weimer. And I believe John Peterson is participating remotely for purposes of swearing in. So if you see him, he's actually John Peterson with an O, not to be confused with Jeff Peterson with an S-E-N at the end.
And Mr. John Peterson, if you could raise your hand. I don't see Peterson in the room. I do see a John. I don't know if that's John Peterson.
Is there any hand going up, Ms. Larson?
There are not.
There's a physical hand in that conference room. Somebody raised their hand.
Okay, so here's.
There we are.
Okay.
That's a legitimate hand raised.
Yeah, the real thing. Nothing virtual about that.
And Mr. Jacobs, just to confirm, will we be hearing from Melinda Harper? Is she in the room or remotely?
No, Mr. Weiss will be testifying as our expert forensic accountant. Ms. Harper is a colleague of Mr. Weiss, and when we listed witnesses, we weren't sure which of them would be testifying. So Ms. Harper will not be called and will not be sworn in.
Okay, so just to run through to make sure we have this correct. We are not swearing in today Melinda Harper, Jeffrey Kaufman, Kevin Kaufman, Marco Batala, or Miles Weimer.
Or Alan Harrison.
Or Alan Harrison, okay.
And I believe also we're not swearing in Jeff Ricard.
Okay. Thank you.
So with that, perhaps, I guess, Mr. Davenport, it's your turn to run down the list of these witnesses.
Mr. Jacobs, it might be easier if you just have all of those assembled in the room, go one at a time. I state your name, swear to tell the truth.
That's fine. Happy to do that, gentlemen. In right to left or left to right, whoever wants to start. Time out. We're getting a bad echo. Is anybody on a personal device with computer speakers as well as the monitor in there? If so, you need to mute that device and only have audio serving the flat screen monitor and the camera in there. Are we set to go? You want to try that again? Okay. We didn't hear that. No, this is not going well. Give us just a couple minutes. If we can't resolve this, we could do the swearing in at the beginning of our defense case. I don't want to hold up the proceedings.
I, Avi Mailer, swear to tell the truth.
Great. Let's start over. I don't want to speak over you. Speak up as you do this.
I, Jeff
Wait,
Peterson,
stop.
swear
Hold on.
to tell the truth.
I'm sorry.
I, Michael
Please.
Huddle, swear to tell the truth.
I, John Peterson, swear to tell the truth. I, Max Knox, swear to tell the truth.
Very good. I was speaking over the first couple of
I, Manuel
sounds.
Silva, swear to tell the
Commissioners,
truth.
I'm sorry. Man, that was Manuel Silva. Avi
We've
and
lost audio in this room, so we need to reconnect. Hold on just one moment.
no, we got that audio, but they were not hearing. Oh, they weren't hearing me. That's why they were speaking over me. Shall we do that one more time?
Mr. Jacobs, yes, please. If we could do
For
that one more
clarity of the
time.
record. Hang on one second.
I'm going to go ahead with Mr. Stoltz and Mr. Weiss while.
That's fine. Please
That's
do
being
that,
worked out.
and then we'll get going. Back in the room.
Mr. Stoltz, please go ahead.
I, Rick Stoltz, swear to tell the truth.
Thank you. Mr. Weiss? I didn't hear that. I'm sorry. If anybody else heard it, let me know.
Is Mr. Weiss admitted? I'm not seeing him. Oh, there we go. Great.
Yes, he's
Try
admitted,
again.
but he's appears to be muted.
Sorry. I, Greg Weiss, swear to tell the truth.
Thank you, Mr. Weiss.
All right. It appears that the conference room may be back up and running. Thank you, Mr. Stoltz. Thank you, Mr. Weiss. If we could redo the conference room again now, that would be great.
I agree. Avi Mailer, would you start again, and we'll do this one more time and run down the list, and I won't talk over anybody. Please start.
I, Avi Mailer, swear to tell the truth. I, Jeff Peterson, swear to tell the truth.
I, Michael Huddle, swear to tell the truth.
I, Manuel Silva, swear to tell the truth. I, Max Knox, swear to tell the truth. I, John Peterson, swear to tell the truth.
All right. I think we're good now. Thank you, everyone. And I'll repeat the same information as the last time. Please consider yourself under oath for the entirety of the hearing this week. We will not re-swear you in should you go away and have to come back for questioning later or something like that. Thank you all.
Okay, let's remove KPK's witnesses from the panel. And Ms. Rosenberg, I think you need to let us know, do you have your witnesses on the panel at this point?
No, we need to have re-elevated Nikki Graber and Joe McLaren.
Okay, give us a sec. We'll get that done.
Mr. Chairman or Hearings Manager Larson, my apologies. for the interruption. My colleague Kurt Mueller needs to be made a panelist again.
Okay, give
so
us
that
a
he may
second.
participate. Thank you.
And Hearings Manager Amaro, once Ms. Larson is done, if you could switch to speaker view so that we have the speaker being viewed as opposed to the panel. I think that will make it a little easier. Okay, I think we've got Ms. Rosenberg. I believe you've got your two witnesses. Mr. Jacobs, you are present, as is Kirk Mueller and Lucas Satterley on your team. And so I think we've got all the witnesses sworn, and I think we're good to go. Is everybody comfortable with moving forward? All right, Ms. Rosenberg.
KPK is fine. Thank you.
Thank you. I'm Kelly Rosenberg. Good afternoon. I'm Kelly Rosenberg, Staff Enforcement Officer. We are presenting the UPRR 43 Pan Am flow line matter, which relates to KPK's failure to properly maintain and repair a flow line near a residence and county road that resulted in significant adverse environmental impacts. You may hear staff refer to this as the near miss matter. And why is that? Because, as evidence has shown and will show, KPK's 6 rule violations resulted in a massive flow line gas release, one that could have caused an explosion in close proximity to people, and one that did result in contamination of soil and water. Through staff testimony, as well as the exhibits and stipulated facts, we will show that KPK failed to immediately control and contain a known release, failed to safely maintain and repair the flow line, failed to properly maintain an isolation valve, failed to take proper environmental precautions, and failed to properly store EMP waste. Nikki Graber, Staff Environmental Protection Specialist, and Joe McLaren, Staff Integrity Inspector, will describe how KPK's failure to properly maintain and repair the flow line resulted in an alarming gas release, as well as how KPK's actions and inactions resulted in adverse environmental impacts. In addition, Jeremy Farron, Enforcement Supervisor, will describe how the proposed penalty was calculated. This case is simple. The parties have stipulated to many of the pertinent facts. Everyone agrees that KPK was and is the operator of record of the flow line, that the surface owner alerted KPK of an ongoing gas release in the flow line, that the release location was between 50 to 400 feet or so of various sensitive receptors, including a public byway and a residence, that 4 days after staff was informed of the release, 4 days after KPK was informed of the release, staff inspected the location and observed an open excavation with an exposed flow line. The parties agree that KPK was storing hydrocarbon impacted soil from the excavation at the site, and there is no dispute that staff observed an active gas leak. Everyone further agrees that upon seeing the gas leak, staff immediately required KPK to come to the site to temporarily stop the leak. The testimony will also show that while staff was on site, a separate KPK crew arrived and attempted to engage in repair activities on the flow line without first properly securing the leak, putting everyone at risk. Staff will also describe how upon discovering the active gas leak, they had to immediately move upwind and feared that an ignition source might set off an explosion. Yet despite admitting to so many facts, KPK denies that it committed any regulatory infractions, which underscores the lack of seriousness with which KPK approaches maintaining this flow line. But KPK did commit rule violations here. And based upon the stipulated facts, the exhibits, and witness testimony, we will establish that it was more likely than not that KPK violated 6 2019 rules. And just a point of clarification, because it's now staff presentation time, my understanding is that now we move on to the witness portion, or would you like to allow KPK to offer an opening if they wish?
I believe we'll just move directly to your witnesses, and then KPK can present its case at its time.
Great. Okay. Then we call Nikki Graber.
Can you hear me?
We can hear you, Ms. Graber.
Thank you.
Good afternoon, Ms. Graber. Can you please state your name and your job title?
I'm Nikki Graber. I'm the Northeast Environmental Protection Specialist.
And how long have you been at the COGCC and in what roles?
3 years this Friday, actually, and it's been the same role.
And what is your general education and experience?
I have a bachelor's degree in geology as well as a bachelor's degree in sustainability with a focus on energy. I'm currently working on my master's in environmental policy. Prior to coming to the COGCC, I was an environmental consultant for 5 years. And prior to that, I was an on-site geologist working rigs in Weld County.
Tell me what you did to prepare for today.
I met with all your staff. I reviewed inspections reports, reviewed rules, looked at photos, looked at relevant documentations, and I visited the site.
And aside from your lawyers and enforcement staff, who did you speak to while preparing for your testimony?
I spoke with Kari Brown.
So now I'm going to move on to the factual portion of your testimony. And, excuse me, some technological things. Can you tell me a basic overview of the location that is relevant to this NOAV?
The incident was discovered by the landowner and they notified KPK of the flow line release. KPK then submitted a Form 19. Since then, both soil and groundwater impacts have been identified at the location. Vertical and lateral extents have not been defined. The excavation remains open as of last week when I visited the site.
And can you tell me about the nearby sensitive receptors?
So if you look at your screen, we have an aerial map. To the northwest is Big Dry Creek and its associated mapped wetland. It's also adjacent to Weld County Road 4. And directly north is a residence, which has a domestic water well.
And why were you at the flow line on September 23rd, 2019?
So when the Form 19 was filed, it's frequent for environmental protection specialists to inspect these spills and releases.
Tell me a little bit about when you arrived.
So I arrived at approximately 2 p.m. with Kari Brown. When we got there, Joe McLaren was already on location. We didn't plan to meet him there.
And what did you first observe when you arrived on site?
I observed 2 separate bell hole excavations. One was on either side of County Road 4, and they were open to expose the flow line.
And can you quickly just inform people who don't know what generally is a bell hole excavation?
It's a common term for excavations open to access a line. It's different from a remedial excavation in that it just has the purpose of accessing and repairing.
Great. And, excuse me, what made you believe that the southern excavation was an access for repair?
So the excavation to the south appeared to have no environmental impacts, whereas the excavation to the north had impacts, and that is where the lat long mapped for the spill and release as reported in the Form 19.
And can you tell me what we're looking at here in Exhibit 705?
That is an excavated stockpile of impacted soil from the excavation.
And tell me the significance of this pile of impacted soils.
So it is stored improperly. There's no liner under it, and there are no stormwater best management practices, which are meant to control runoff.
And, sorry, okay, thank you. And does that have environmental impacts?
Yes. So if it were to rain or wind, or the fact that the material is sitting on unimpacted soil, presents effectively a secondary spill.
Can this stockpile here in Exhibit 705 cause or threaten to cause adverse environmental impacts?
Absolutely.
And I'd like to ask you about the environmental impact now.
Okay.
What did you observe next after you saw this southern excavation and the pile of impacted soils?
So we moved in to take a look at the excavation. Upon approaching the edge of the northern excavation, we heard a hissing noise. That prompted us to move upwind of the excavation, where gas was observed releasing from a hole in the flow line, as well as pooled liquid hydrocarbons beneath the line. Based on this observation, we evacuated the location by moving approximately 400 feet west on the county road. That was crosswind. Kari and I contacted John Axelson to notify him of the incident, while Joe notified KPK.
And I'm going to attempt to show a video of the gas release. And is that what you observed that day?
Yes, it's missing the audio, which was quite clear.
Oh, well, I have audio on my end, so maybe it just needs to be raised louder. I apologize for that. What was your impression of this gas release?
That the line had not been properly isolated. But honestly, my primary point of concern was public safety. This is an uncontrolled release of both liquid and gaseous hydrocarbons in a really sensitive area. I mean, the release was discovered on September 19th, which means that this was ongoing for 4 days prior to our arrival. Hazardous atmosphere could have developed, and I was concerned what would have happened if we did not arrive when we did. Honestly,
go ahead.
I was just going to say, honestly, I know several of us lost sleep over this incident.
What were your environmental concerns related to this release?
The release had been ongoing for 4 days to atmosphere.
And was your concern that KPK had not immediately contained it?
Yes.
And what sort of impacts were you concerned about?
So soil and groundwater, due to the adjacent level of the wetlands, definitely we were concerned about groundwater, and additionally air.
And then what happened next?
So approximately 20 minutes later, several people arrived on the location at about the same time. First, the landowner approached our vehicles because they were concerned about the site conditions. At about the same time, an unrelated KPK crew arrived and approached the southern excavation with equipment for repairs. And then additionally, another KPK crew arrived at the northern excavation in response to Joe's phone call. At that point, I went back to approach the KPK crews while Kari and Joe stayed talking with the landowners.
And then this unrelated KPK crew that you just mentioned, what made you think that they were not related to this gas release?
They did not approach our area or interact with us at all. They went directly to the southern bellhole via a gate access off of County Road 17, which is to the east.
And you mentioned that that your impression was that they were doing repairs. What did the crew do to suggest that they were doing repairs?
Upon arriving, one member approached the southern bellhole while others began collecting equipment. Based on what I've seen in the past on KPK sites, I've seen crews of similar size carrying similar equipment, repairing KPK flood lines.
And what's the significance of whether that crew were doing repairs or whether they were dropping off equipment as KPK states that they were?
I mean, they were in potential danger regardless. They were downwind from an active gas release with no indication from their position that the isolation valve was not functioning properly. However, had they initiated the repairs, there could have been significant harm from a spark or other release.
And what could the spark have done?
It would have caused an explosion had hazardous atmosphere developed.
In KPK's answer, they said that they weren't making repairs and that they were only unloading pipe. If that were the case, were you concerned then about any environmental impacts?
Yes. Go ahead. They were downwind of an active release. That hazardous atmosphere isn't contained to that area, especially with the breeze and the conditions.
But if they were just doing repair, if they were just dropping it off, then would you have felt it was safe?
Yes, or no, I would not have felt it was safe. Per the specs that KPK provided us for the plastic material, hazardous atmosphere can cause a potential hazard due to static discharge off the pipeline. I believe you have it up now. In a flammable gas or explosive dust environment, a static electric discharge can cause an explosion or fire.
So then from your perspective, even if they were simply unloading pipe, that still could have presented a dangerous situation in this scenario?
Correct.
But you thought that they were actually engaged in repair work?
Correct.
And did you think that KPK was engaging in reasonable precautions here?
No. So the crew did not come over and inspect the other excavation. Had they been using reasonable precautions, they would have checked the isolation valve, inspected the leak area, and then approached the area.
And what did you do when you saw this crew doing what you thought was initiating repairs?
I approached Mr. Max Knopp and I asked him to stop work due to imminent threat, and he went over and directed the crew to leave. I also requested that he submit a Form 22 accident report for the near miss due to an uncontrolled release, as well as a Form 44 for a grade 1 gas leak.
And when you spoke with Max, Mr. Knopp, did he mention the reason the crew was there? Did he say they were just dropping off materials?
No.
Okay. And what is the status of the flow line now?
The excavation remains open with groundwater in it. There's a large disturbance area adjacent to this residence. These pictures reflect current. The site has been unsecured and impacted soils have been observed with inadequate BMPs on multiple occasions. We've had to address this over additional corrective actions on inspections. And we also have no evidence that vertical and lateral extent of impacts have been defined.
Great, thank you. I have no further questions at this time.
Thank you.
Mr. Jacobs, do you desire to cross-examine this witness?
Yes, I do. Thank you. Ms. Graber, I'm John Jacobs, counsel for KPK. Good afternoon.
Good afternoon.
I believe that your inspection report, our Exhibit C, your Exhibit 703, indicates that personal poor gas monitors were worn by you and your colleagues at the site. Is that correct?
That is correct. That's standard operating procedure when conducting work in the field.
Mr. Jacobs, can I stop you for just for a sec?
Sure.
Just kind of a point of order in doing a trial via Zoom. I think it would be helpful for whomever has the floor to have access to share screen. And similarly, so if we could unshare Ms. Rosenberg's screen, yeah, there you go. And that way, so if you and counsel for staff could follow that protocol, that might be helpful for everybody. Is everybody okay with that?
I appreciate the suggestion.
Okay, so let's do that.
Thank you, Mr. Chair.
And then Ms. Amaro, if we could get rid of the participants piece to the right-hand side of the screen. I don't think that's necessary, and it'll give us more opportunity to hear the witness and counsel. Okay, sorry about that interruption, Mr. Jacobs.
No worries. And I am sharing, and you should see our Exhibit C, your Exhibit 703. You recognize that?
Yes.
And you can see it okay.
I can't read it.
Oh, I'm sorry. Maybe I can zoom in. I'll also maximize this. Is that better?
Yes.
It's just a little too big. There we go. And I'm going to highlight. Second. Now, maybe I won't, but you can see my cursor.
Yes.
Person, and in this uppermost paragraph, I guess it's the third paragraph on this page of that exhibit. You see the second sentence begins personal poor gas monitors. That indicates that your personal poor gas monitors and those of your colleagues that visited the site the day in question that you just described in your testimony did not indicate at any time hazardous atmosphere. Is that correct?
That is correct. However, we were at the upwind location of the excavation.
Understood.
We did not enter the downwind area.
Thank you for your answer. Just answer the question asked, please. Your counsel has an opportunity for redirect if necessary.
Okay.
Thanks. It appears from your testimony that you may be reading a script, and if so, I'd like to know if you prepared that or you had assistance or someone else prepared it for you.
I prepared it to help guide myself.
Okay. You indicated that this was a massive gas leak, but did you measure the gas leak?
I did not.
So how do we know that it was massive?
I think that depends on your definition of massive.
But you did not measure it in any event, correct? No. And you don't know that this was leaking for 4 days. You just assume that based on the date of the start of work and the date of your inspection. Is that correct?
Correct.
I have no further questions on cross for this witness. Thank you.
Thank you, Mr. Jacobs. Redirect by Ms. Rosenberg.
Yeah, just a couple of questions. Thank you. Ms. Graber, based on your experience, what was the size of this leak relative to others?
I wish that video sound would have come through. It was a vigorous release. It's hard to quantify without the proper equipment, yes. It's more than a tank blowdown, and it's hard to define.
And I just would like to let the commissioners know that video gas leak has been an admitted exhibit. So that is in the record for you. And then can you clarify one last question? What is the significance of the downwind upwind situation?
So if a hazardous atmosphere had formed, then upwind, it would be carried by the wind. So when we were standing upwind, you would not expect our forecast meters to alert, but we did not enter the downwind atmosphere as a precaution.
Thank you. That's no further questions.
Thank you.
And now at this time,
Just a second, Ms. Rosenberg. We're kind of new to this, but if this witness is done, I'm looking to see if any fellow commissioners have any questions before we move on. And now I can't see all my fellow commissioners, so. Commissioner Najapa?
Thank you, Mr. Chair, and thank you very much for the testimony and for the questions and cross-examination. There was, I believe, in the initial questions from Ms. Rosenberg, in discussing the, I think it was the presence of groundwater. You had a couple of images there of the water that was present. And Ms. Graver, you mentioned that this had been something that had been observed prior and in separate corrective actions that had been requested. Can you elaborate a little further on that, please?
It was observed after this incident. So at the time of the initial inspection, they had not dug much further down. Subsequently, we've been to the site frequently, maybe every 2 weeks, and we've observed a hydrocarbon sheen on the groundwater and groundwater above that flow line level.
Thank you, Ms. Graver.
Thank you.
Anyone else from the commission? Okay. Ms. Rosenberg, your next witness.
yeah, we would like to call Joe McLaren.
Good afternoon.
Give me just one moment here to get my. Thank you. Good afternoon, Mr. McLaren. Would you please state your name and job title?
Yes, I'm Joe McLaren. I'm our Eastern Slope Integrity Inspector.
And how long have you worked at the COGCC and in what roles?
7.5 years. My first 2 years, I was Southwest Field Inspector down in Durango. And the remaining time, I've been in my current role on the Eastern Slope working out of Denver.
And what is your general education and experience?
Sure, I've got a Bachelor of Science in Geology from Fort Lewis College. Approximately 25 years in the oil and gas industry. Most recently, I was a project manager with a pipeline contractor. Prior to that, I spent the bulk of my career as a division manager for an oil and gas chemical company with an emphasis on integrity solutions for producing wells and pipeline systems.
Thank you. And what did you do to prepare for today?
So today I spoke with, I reviewed my field inspection forms, the NOAVs, related photos, spoke with our lawyers and staff.
Great, thank you. And as you know, staff seeks a finding that KPK violated 6 separate rules, some focused on the environmental issues and some on the technical. I'm going to have you speak to the technical rules. Sorry, there we go. Sorry. I have some general questions for you about the near miss site. Can you tell me the basic history of your involvement with the flow line as it relates to the NOAV?
Sure. So I review our Form 19 spill reporting. We received a Form 19 spill report indicating there was a reportable release pertaining to an integrity issue with the flow line, and I went out to inspect.
And it was that on September 23rd?
Yes, it was.
And tell me a little bit about when you arrived.
So when I arrived, I was the only one on site. I observed 2 open excavations, one on the south side, one on the north side of Weld County Road 4. In the bottom of both excavations was an exposed 6-inch carbon steel flow line. I took a look at that south excavation first and then made my way over to the north side of County Road 4. And about that time, shortly thereafter, both Nikki Graver and Kari Oakman arrived on site.
And then what did you do next?
At that point, we made observations and noticed that there was an active gas release in the north excavation from the flow line. So that's where we played it safe and moved upwind and developed a plan from there. I phoned Max Knopp with KPK and requested immediate response to the active gas release.
And why did you move away?
We moved away to be in a safe position and upwind from the active gas release.
And then what happened after you called Max? Mr. Knopp, excuse me.
So then I noticed a KPK roustabout crew approaching the south excavation area. I believe they were driving a truck and a trailer full of materials and equipment. They entered through a gate on the west side of Weld County Road 17 into that south excavation area. Shortly thereafter, Max and other personnel from KP Kaufman arrived on site in response to the gas release.
And then what did the crew do upon arrival, the one that you called there to fix the leak?
So they assessed the situation and determined that isolation of the line was not possible via the 2 isolation valves. So they called in a vacuum truck, a piece of equipment, to tie into the line, to pull liquids and gas from the line and reduce the pressure on the line.
And would reducing the pressure stop the leak effectively?
Yes, it did.
And then how did you first find out about this release?
So again, that was through the Form 19 spill reporting process. I reviewed the incoming 19 and saw the release. And
I'm sorry, can you repeat that? I didn't quite catch that. I apologize.
yeah, that was through the Form 19 spill reporting process.
And what day was that filed?
That was filed September 20th, 2020.
And as far as you know, when was KPK alerted of the leak?
As far as I know, if they put in their 24-hour notification, it would have been on the 19th of September.
So then you went 4 days after KPK had been notified. Is 4 days in this context acting as soon as possible to correct this type of release?
You know, this is a situation where KPK apparently responded to the notification of release by the landowner. However, they failed to monitor and properly isolate the flow line and eliminate the leak, and then monitor the line to ensure that the leak had been stopped.
So if I'm understanding you, on the 23rd day when KPK came out, their response was effective in temporarily stopping the leak, but the days preceding that, was that effective?
Yes. I'm assuming an active release was taking place.
And is it common for gas pipes to release and then stop release and then release and stop releasing?
I don't believe so. I think there was a leak and a flow through one of the isolation valves or both, and that was probably an ongoing situation.
And then had KPK been considered to be operating the flow line between September 9th and September 23rd, and why or why not?
So the flow line wasn't actually moving product for processing and sales. However, active operations were taking place at the site in the form of response to the spill, excavation, remediation, and preparations for repairs to the flow line.
What was the significance of this release?
The significance is that it's an uncontrolled gas release of a highly combustible and flammable material, natural gas, and it's adjacent to a public roadway. There's a residence, an occupied residence, approximately 250 feet to the northeast. And it could, with an ignition source, it could have been catastrophic, resulting in a fire explosion, putting not only KPK personnel at risk, us as inspectors, and also the residents of the property or the public as passersby.
And then you see leaks in your position pretty routinely. How does this release compare to typical releases?
You know, it was significant. I mean, it was audible, it was visible, it was pressurized, and it was ongoing. So it was definitely had the makings of a bad situation.
So we haven't said anything bad, but just we're going to add loss.
Thank you. What does it mean? So with regard to the allegation of violation of Rule 1102J1, what does it mean to properly isolate and depressurize a flow line?
So to properly isolate the affected, the failed section of flow line, there needs to be a physical separation from the pressure sources. So you've got to have two valves shut, one on the upstream side and one on the downstream side of the point of failure on the flow line. Those valves have to be operational and they have to create a positive seal with no flow through of any kind of gas or liquids. At that point, there still may be some pressure in the failed section of flow line that needs to be blown down or redirected in order to completely vacate the line to zero pressure.
So similarly, why does it matter if a flow line is isolated and depressurized?
Then once again, I mean, if the flow line's not isolated and depressurized, the possibility and probability of having flammable gases and liquid in that segment of line is good. And again, an ignition source can result in a fire explosion that could be harmful and cause injuries and or death. Thank you. Now with regard to Rule 1103A with performing maintenance or performing functionality tests, did KPK ever provide you any annual flow line test records or maintenance records? No, I didn't receive any, but I don't typically receive that information. That would go into our integrity engineers in our office, but they did not provide us any as communicated to me by our group that I am aware of. And were you aware that in their answer, KPK said that they don't maintain these sorts of records? I am aware of that, yes. Now tell me a little bit about debris getting caught in an isolation valve, generally speaking, what role that plays in causing leaks like this. Sure, so over time in an operating pipeline or flow line, heavy hydrocarbons, scale deposits, corrosion byproducts, and miscellaneous substances can build up in the line, usually down in the bottom of the pipeline in that 6 o'clock position. Those kind of move through the pipeline and can get hung up in valve assemblies. So typically operators are aware of this situation. It's real common as maintenance activities to pig your line, flush your lines periodically, chemically treat the lines if solids deposits become a problem. Does regular maintenance stop this junk from building up at the bottom of the pipelines? Yeah, regular maintenance will aid in removing it and minimizing the accumulation of these deposits. And does debris
typically get caught up in properly functioning isolation valves?
Debris should not be an issue in a properly functioning isolation valve because that valve is supposed to be tested and maintained. And if it's being done, if those activities are being done on a routine basis, then those sorts of materials and issues are remedied at that time.
Thank you. And so then tell me a little bit about what happened after that inspection on the 23rd.
So after that inspection on the 23rd, I followed up the following day with my FLIR camera to ensure that the gas release had been stopped, and it was. At that point, moving back to the conversation that Max Knopf and I had on location, we had talked about doing a permanent fix to make sure that the gas leak was going to be eliminated. And in the days to come, the next 3 days to come, KPK personnel installed temporary valves on the south excavation and north excavation ends of the flow line to effectively stop the release.
And going back just a little bit, you used a term there, FLIR, what is that?
A FLIR camera.
FLIR camera.
Yes, it's an optical gas imaging camera that has technology that's capable of seeing gas as it's being released or emitted from a pipeline.
Great, thank you. At this time, I do not have any further questions. Thank you.
Okay.
Thank you, Ms. Rosenberg. Mr. Jacobs, do you have cross-examination for this witness?
Yes, I do. Thank you, Mr. Chairman. Good afternoon, Mr. McLaren. Again, John Jacobs for KPK. Just a few questions. You mentioned that KPK indicated, or you confirmed that in their response, they said that they did not keep records of their annual functionality tests. Are such records required by commission rule at that time or currently?
Not that I am aware of.
And you also talked about regular maintenance of the consolidation flow line. Is any such maintenance required currently by commission rules at the time of the incident or presently?
Yes, and that falls under our rule 1102I.
Do you believe that, or have any evidence that 1102 was violated for failure to maintain this UPER 43 consolidation flow line?
I'm sorry, will you repeat that question?
I don't believe that a violation of 1102 is being alleged here for failure to maintain this flow line. Is that your understanding?
No, my understanding is that are you referring to the isolation valves?
No, I'm referring to maintenance, pinging, flushing the line, putting corrosion inhibitors and things down the line that you described in your testimony a moment ago. I want to know if that sort of maintenance that you described that might address propensity for debris to form and accumulate in a line is required by current commission rule.
It is my understanding that that would be addressed in our integrity management part of our 1100 series rules.
You're not citing a specific requirement that says that needs to be done, and you're not citing a violation of that specific requirement in the 1100 series, are you?
Objection. Are we talking about current rules or rules in 2019? I'm not clear what the relevance is here.
Either or both. I phrased it in the alternative. I'm allowing the witness to answer currently or at present. Or, excuse me, at the time of the incident or at present. Mr. McLaren, can you answer either of those?
I cannot answer those at this time. I would have to read through our rules.
And your statement that debris should not be an issue, is that a statement that debris will never form even if one performs maintenance?
There is a possibility.
And is there a way to predict that debris will clog or foul a valve and impair its functionality, notwithstanding, well, leave it at that, it can impair its functionality? Is there a way to predict whether debris will form or not, or will foul a valve?
Sure, follow your routine maintenance per our 1103A rule, and an operator should have an indication of whether or not their valves are junked up and fouled up by debris.
You're talking about a history of fouled valves, that's one thing. I'm talking about a single isolated occurrence, and you've not put on any evidence to the contrary. We're talking about one incident of a fouled valve. Is there a way to predict when that's going to happen?
Not that I'm aware of.
Thank you for the answer. Just combing over my notes, if you'll bear with me. I have no further questions on cross for this witness.
Thank you, Mr. Jacobs. Ms. Rosenberg, any redirect?
No redirect on this witness. Thank you.
Okay, looking to fellow commissioners, do commissioners have any questions for this witness? Commissioner Messner?
Thank you, Mr. Chair. Just curious, Mr. McLaren, in your experience, which seems significant in the oil and gas industry, particularly around flow lines, is it a best management practice of a good operator to maintain maintenance logs on their flow lines in order to be able to determine whether or not there are issues or maintenance items that need to be addressed and to have historical record of that?
Absolutely. The documentation of integrity tests out in the field is essential for keeping track of all of your infrastructure out in the field. Absolutely. It's a common thought in the oil and gas industry that if there are no records to your testing, the test never happened.
Thank you, Mr. McLaren.
Sorry, seeing none, this witness may be released. And Ms. Rosenberg, you're up with your next witness.
Thank you. Staff would like to call Jeremy Farron.
Can you guys hear me?
Yes.
Okay.
Good afternoon, Mr. Farron. Thank you for being here today. Would you please state your name and title?
My name is Jeremy Farron. I'm the enforcement supervisor at COGCC.
How many years have you been with the commission?
I've been at the commission since 2014 and as the enforcement supervisor since 2017.
And can you describe your role at the commission?
So I oversee the enforcement program. So that's, I think, 3 people in-house and some assistant attorney generals, usually 3 or so.
And can you describe your experience specifically with calculating and reviewing penalty calculations in enforcement matters?
So I have extensive experience calculating penalty calculations. I was here when we crafted the new rules. I was here when we crafted the enforcement policy. And I've been here for years doing that work. And especially when I became supervisor at that point, I reviewed pretty much all penalty calculations.
And can you explain what prescribes how a penalty is calculated for enforcement matters? Excuse me.
Yeah, so it's a combination of 525, new rule 525, and the enforcement policy.
Thank you. And now I'm going to try to share. Can you see the claims table, Mr. Farron?
Yes.
Great. Let's talk about the nuts and bolts of calculating penalties generally. Regarding days of violation, how does staff determine the start date?
So usually that's fairly obvious based on maybe the language of the rule or corrective action given by staff.
And how does staff determine the end date?
Yeah, so that's going to differ substantially case by case because it's subject to a phrase that's in the act and the rule, as I recall. When corrective action is commenced to the director's satisfaction is that phrase. And so, when staff, the director is satisfied is going to vary based on the facts.
Is the commission obligated to assess a penalty for each day the evidence shows a violation continued?
Yeah, so Rule 525 requires us to impose a penalty for each day.
And then what does that mean in practice?
It's exceedingly rare to have a single day penalty. It's usually a continuing series of days where we calculate a penalty for each of those days.
Okay, thank you. And then regarding rule class, how does staff determine the rule class, 1, 2, or 3?
Yep, so those are established in the enforcement policy. So we'll look at the enforcement policy, and here we're looking at a violation of 324 big A, and you'll see it's a class 3. That comes straight from the policy.
Okay, and do those classifications comport with the narrative description found in 525?
Yeah, so there's some language in 525 that was in effect when we classified all the rules historically. So yes, they comport as far as I know.
And is that a fact-specific determination?
So it is not. It is. The rules are classified in isolation ahead of time without regard to facts on the ground. And so, like I said, all of these classifications predate the NOAVs at issue here.
Great. And then regarding the impact classification, how does staff determine the impact classification?
Yeah, so that's a collaborative process with staff where we, discuss, whether they think it's a minor, a major, or a moderate. And again, here, 324 big A, it looks like we came to the determination with staff's input that this was a major impact.
And do those impact determinations need to comport with the narrative description found in Rule 525?
Yeah, so it's the same thing. There's a description in that table in 525 where we use that to tell us, does it fit into one category versus another?
Okay, thank you. And now regarding the daily penalty, where do the presumptive daily penalties come from?
Again, straight out of 525, there's a little 3x3 table in there, and the daily penalties are listed there.
Okay, and then with regard to the gross penalty, is that just a daily penalty multiplied by the number of days of violation?
Yeah, so that's the straight math, and it gives you a gross penalty amount.
And is that what is displayed here on the claims table?
No, so we omitted that column and instead included the requested penalty column, which is the calculation having also run through the duration matrix.
Okay, great. And what is the duration matrix?
So it's a decline curve established by the policy that decreases daily penalties from the presumptive amount, as a long duration violation goes on.
What is considered a long duration violation?
So in the policy, it's anything over 10 days. And there's a table in the policy that spells that out.
And then is staff, when calculating the penalty, required to use the duration matrix?
We are not required. However, we did in this instance on, I think, all the violations. So it reflects that discretion when that column, the requested penalty column, includes that discretion.
And so then if that had not been utilized here, those last columns would be much larger?
Yeah, the gross penalty would have been larger than the duration adjusted penalty that you see here.
And then as the last step, does staff consider the application of aggravating and mitigating factors?
We do. So in a previous version of this table, there was some allowance for pattern of violation. I think KPK is also requesting maybe one mitigating factor in this case, in the near miss case. And so that's a separate calculation at that point. neither is reflected in the table as we're looking at it now.
And generally speaking, though, how are the aggravating and mitigating factors applied?
Yeah, so it's a percentage. It's usually applied as a percentage increase or a percentage decrease.
Okay, great. And now those are some general penalty calculation questions, but now let's turn to the calculation for the near miss matter. With regard to the rule class, these are all class 2 or 3 rules. Why is that?
That's just, again, established by policy. The rules that were cited in the NOAB were either class 2 or class 3.
Okay, so did staff make any adjustments to those classifications?
No, we stuck with what was in the policy.
And then with regard to the presumptive daily penalty, were those penalties adjusted?
No, so those are, again, straight out of 525.
Okay, and then with the dates in the claim table, where can the commission find out more about these dates?
So in our pre-hearing statement, there is a discussion, obviously, of various dates, but that's the place to go to get some information about exactly what happened on 9/23/20.
And then in this instance, what role did the stipulated facts play?
A number of the dates that you see here and in the claims table that was filed come essentially straight out of the stipulated facts.
Okay, thank you. And then regarding the impact classification, do we see all 3 categories here?
So in this instance, we do not. I think we only have major and moderate. I believe in some of our other penalty calculations, there were some minors applied.
Okay, and did staff consolidate any violations in this matter?
Yeah, so I think, so I'm not sure if I can see it. If you scroll down, I believe there is a consolidation there. Yeah, right there. So the 1103A and the 605D, we voluntarily consolidated those 2 violations because we felt like they were duplicative.
And what impact did that have on the penalty?
That inures to KPK's benefit. Instead of having 2 individual penalty calculations, you just end up with 1.
And did staff apply the duration matrix here?
Yeah, I think I said consistent throughout all of these matters, all 8, we applied the duration matrix.
And what impact does that have on the penalty amount?
Same, it decreases the penalty requested by staff.
And then with regard to prior enforcement orders, did staff consider those when calculating these penalties?
Yeah, so we try to maintain some consistency between orders, historic orders, and current orders, and we did that here. So we looked at historic orders to see if they had similar penalty calculations, including, I think, a few case orders that have been entered even against KPK.
Thank you. And now turning to some of the penalty arguments that appear in KPK's pre-hearing statement, can you touch on KPK's inability to pay argument? Is that something staff considered here?
Sorry, I was drinking some water. We did not. Generally, in a settlement posture, we would consider inability to pay. This case obviously wasn't settled. It's here at hearing. And so we did not, and instead everything was just submitted to the commission for its consideration. So the staff didn't object or take an opinion or really even closely review that information. So it's for the commission to determine.
Okay, thank you. And with regard to this near miss matter, can you touch on the argument with what about the end dates, the penalty end dates in this matter?
So my understanding is that, again, commencing corrective action to the director's satisfaction, there seems to be a disagreement between KPK taking some initial steps, I think the use of the vac truck, versus something that staff thought was more effective, which was the installation of some temporary valves. So as I understand KPK's argument, and it's not terribly clear in their pre-hearing statement, it's just sort of a statement without a lot of detail in it. I think that's the dispute we're talking about. What was the true end date here? And staff believed that the installation of those valves was the end date because it stopped the release. That's not the end of this situation, right? There's a lot still going on to this day in that location, but the installation of those valves stopped the release, which we thought was the commencement of corrective actions sufficient to stop the penalty clock.
Thank you. And then why did staff classify the impact as major?
I'm sorry, your mic broke up a little. Can you repeat that?
In this instance, why did staff classify the impact as major?
Honestly, I think it's fairly obvious that this was a significant adverse impact, right? I mean, there's impacts to groundwater, there's some duration of gas leak occurring at this location, unmonitored. That in and of itself is an impact, let alone, you know, what was happening to the soil and potentially to the water. So in staff's determination, this is a significant adverse impact.
Thank you. And now, actually, commissioners, if I may, may I confer with co-counsel in just a moment, not the witness, but Ms. Stafford for a moment?
Yes.
Thank you. And I do have one sort of last question just to make sure that we're on the same page with regard to KPK's inability to pay argument. In this instance, I didn't quite understand your answer. Did staff consider that here? And if so, why? And if so, why not?
Yeah, sorry. We staff did not consider it in any of the cases, any of the 8. And again, that was because we do that for a settlement. We've done that with AOCs. I believe this commission has seen AOCs with a phrase about inability to pay in them. We did not do that here because this case obviously didn't settle. And instead, everything was sent to the commission for its consideration.
Thank you. No further questions at this time.
Mr. Jacobs, do you desire to cross-examine this witness?
Yes, I have just a few questions. Thank you, Mr. Chairman. Good afternoon, Mr. Farron.
Good afternoon.
I believe you indicated that there's been no settlement in this case since we're at hearing, but that's not for lack of a comprehensive settlement offer from KPK, is that correct?
Objection. That's not relevant here. The discussion about whether or not there was settlement and what was discussed or not discussed at settlement is prohibited by the rules of evidence from being allowed here.
Agree. Objection sustained.
I would like a chance to respond and make my record, Mr. Chairman, please, if I may.
Mr. Jacobs, can you hear me?
Yes.
I don't believe that settlement discussions are something that is relevant to the presentation of this case.
Mr. Farron raised the issue of settlement. He said, we haven't settled because we're at hearing. The cause of not settling is not necessarily because we're at hearing. I think I'm entitled to probe that without getting into the substance.
Okay, without getting into
settlement. Yeah, that's correct. Without getting into the substance of settlement offers, terms and conditions, term sheet, and a lengthy attachment regarding all of the penalty calculations that he just went through. But I digress, if I may.
You may ask.
It's not for lack of having made a settlement offer by KPK. Is that correct?
Correct. KPK made a settlement offer.
And we supplemented that with additional information, even a memo on statute of limitations and our view of penalty calculations.
Objection. This is getting into the details of the settlement.
No, I'm not saying the substance of those arguments. I'm saying we supplemented our offer with additional information. Is that correct, Mr. Farron?
That's correct. There was quite a lot of back and forth.
Not really, as I recall, and I'll ask a question about that. Did you ever submit a comprehensive response to any of those offers or supplemental materials?
I believe they were discussed. I don't know that we submitted something back in writing.
And is it true that in your pre-hearing statement, you indicate that you jointly noticed in May the 8 NOAVs in this consolidated proceeding, now bifurcated twice over, in order to be able to allege pattern of violation and knowing and willful violation. Is that correct?
Objection. I don't know what the relevance of this is. The pattern of violation.
I can tie this up if you'll permit me one more question. Yes or no?
One more question.
In the introduction to your pre-hearing statement.
So I don't recall what was precisely in the pre-hearing statement. So if you want me to answer that, I'm afraid I'd have to see it.
I'm not going to take time to have you look at that. I represent to you that, in fact, the introduction of your pre-hearing statement says that, and we quote that, in fact, in the motion to strike or to continue hearing. That was denied, and we understand that that is water under the bridge. The point, and I'm tying this up, Mr. Chairman, is that once you allege that, once you seek that, you can no longer settle with an AOC. Is that correct? By rule, you cannot do that. You have to go to OFB hearing. Yes or no?
That's not correct.
Any further questions, Mr. Jacobs?
No, I have no further questions. Well, hang on one sec. You say inability to pay was not considered previously in OFB hearings, and yet I'm led to believe, I believe it's correct, that order number 720 entered June 20th, as stated in your annual enforcement report against Bramwell Richard, that may be Richard Bramwell, has an ability to pay consideration in it. And another one is Dakota Exploration LLC, OFB, order number 712, entered March 25th, 2020. So there's two examples of OFB hearings involving a consideration of ability to pay. Do you wish to correct your answer?
I didn't say that it wasn't ever considered. I said it wasn't considered here. And that actually goes to my prior answer, which is that, in fact, OFVs that allege pattern of violation and additional aggravating factors have been in front of the commission in a hearing pursuant to a stipulated OFV. So you can settle, you just still have to have a hearing. And that's what happens with those stipulated OFVs. You end up having a hearing.
I have no further questions for this witness at this time.
Thank you, Mr. Jacobs. Ms. Rosenberg, do you have redirect?
No redirect. Thank you.
Okay, Mr. Farron, I've got a question or two, and then I'll look to my fellow commissioners. I think you mentioned that, and I may have heard this wrong, that the duration matrix was applied to all of the violations in this matter. I think there's 6. I guess, is that true? I mean, as I read it, and if I understand how duration matrix works, the 907A does have a duration matrix application, but I'm not sure that I see that the rest do. Can you help me with that?
And I'm sorry, if I said that, what I really meant was anything over 10 days, it was applied. So if anything has a duration of less than 10 days, it would not be applied. So okay. I'm sorry, I don't have the table up anymore, so I can't answer your question specifically about 906.
That's fine, and I can let you know that the 907A is the only one that was over 10 days. It was 43 days, and the rest were not. So your testimony would be that it was applied to that one because it was over 10 days. Is that right?
Yeah, there's no need to do it if it's 9 days or less.
Okay. And yeah. I've heard the term used a bit about this violation, a near miss. Is that a term that's in our rules and regulations, or is that just sort of the way you guys are talking about this issue?
So as I understand it, that's an industry term. I don't believe it's in our rules. We, amongst council, we wanted to use a phrase that was a little easier to say than UPRR 43G, whatever it is. So that's the phrase we chose, which is, again, I think is an industry phrase, but I don't believe it shows up in our rules anywhere.
Okay, thank you. Looking to my other commissioners, does anybody else have questions of this witness? Commissioner Messner?
Thank you, Mr. Chair. Just a quick question, Mr. Farron. You had indicated that you typically end the penalty calculation upon commencement of corrective action to the director's satisfaction. How do you define what is the director's satisfaction, and remind me where that is in the rules, please?
So that should be somewhere in 525. It's going to be in the penalty calculation section. I'm sorry, I don't have it up in front of me, but that phrase appears there at some point in 525. And then to your previous question, how do we determine that? Like I said, it's case by case. So we sit down with staff and we say, okay, well, when did they do what it is that satisfied you that this was going to eventually be resolved? And so again, it's a fact-specific determination. It's not the first thing, right? It's not the day you submit a piece of paper or whatever, but doing something in the field that looks like will eventually result in a violation disappearing is generally where we come down in defining that end date.
It does specifically say to the director's satisfaction.
Correct. And in that instance, director, we believe, means all of staff.
Correct, as it does with most of the rules. Thank you.
Chair Robbins, I believe you're muted.
Shit, sorry, God dadgummit. I don't see further questions, so I think this witness can be excused. Ms. Rosenberg, do you want to call your next witness?
This time, staff has presented its case in chief. Thank you.
Okay. I'm looking at our agenda, and it does call for a 15-minute break at 2:30. It happens to be 2:31. Let's try to be honest with our breaks, and let's take a break. Let's return at 2:46. And then, Mr. Jacobs, we will hear your case's presentation.
Thank you, Mr. Chairman.
All right. Hi, folks. Hi, folks. Am I echoing? Sounds like it. How about now? Is that better? Okay.
Jeff.
All right. I got my computer fixed. Sorry. Let's let the rest of the folks get into the room, and then we'll get started on KPK's case on this matter. Okay, I think we're all here. Mr. Jacobs, I believe you are up. I see that you have Mr. Mueller and Mr. Satterley with you, but
Correct.
Please move forward with your case in chief.
I have a preliminary item. I wonder if I might request the notes that Ms. Graber was reading from for the testimony. I think we'd be entitled to a copy of those, and I'd like a copy, please. If Ms. Stafford wants to consider that and respond later, that's fine. I'm not trying to hold things up, but I want to make the request.
Okay, request lodged. I'm going to think about it as well. Ms. Rosenberg can think about it, and we'll move forward with your case at this point.
Very good.
May I jump in just briefly? Just a quick question.
Go ahead.
Could we, staff would like to just request a time check if it's possible that we could be apprised of the time that's we've either taken or that's remaining after following our presentations. That would be helpful.
Okay, Ms. Larson is going to do that.
Thank you.
And maybe for Mr. Staff or Ms. Stafford and Mr. Jacobs, maybe before we start up each small segment, maybe let's take a minute and do procedural matters. Does that work for you guys?
That works for staff. Thank you.
Agreed. It's an excellent suggestion, Mr. Chairman.
Great. This is my first rodeo as a judge, so if I have an excellent suggestion every now and then, that's pretty good. All right, Mr. Jacobs, you're up.
May I first, however, do a sound check before we start the clock, Ms. Larson? And we're going back to Peely witness, that's our conference room, where individual witnesses will be testifying in our defense case.
And Mr. Jacobs, if you could remind each of the witnesses to kind of get close to the microphone. Some of those guys we could not hear quite as well when they were being sworn in.
And I will also explain that to get them all on camera, we had, and the mic is integrated into the camera, we had to pull it back, but it's placed much closer to the witness, and I don't think that audio will be impaired, but we will check that, and I will remind them to speak up. Very good. The Peely witness conference room is going to be a number of different witnesses, just for clarification. And I'll be, of course, asking the witness to identify themselves and whatnot. So it'll be clear to you, even though the Zoom window doesn't identify this witness by name. That's because Ms. Lee's link is being used for that conference room feed. Is that clear?
Yeah, that's clear. Let's just make sure that we do identify the witness at the outset.
We will.
That way, listeners will know whom it is that's testifying.
Very good. Thank you, Mr. Chairman.
Okay.
Jeff, could you say 1, 2, 3, 4, 5 just briefly for a little sound check?
1, 2, 3, 4, 5.
Tailed off just a little bit at the end, so just try to project, but I think this will work okay. Did you hear that okay, Mr. Chairman and Commissioners?
Yeah. One last procedural matter, Mr. Jacobs. Ms. Larson, do you have the time check that was requested, and can we go ahead and get rid of that?
Yes, so staff has used 30 minutes and 47 seconds. KPK has used 9 minutes and 15 seconds.
Okay, very good. Proceed with your first witness, Mr. Jacobs.
Thank you, Mr. Chairman. Mr. Peterson, would you please state your name and current employment position?
Yes, my name is Jeff Peterson. I am the roustabout supervisor for KP Kaufman. I've been with the company for a little over 16 years.
Can I pause for just a moment? I don't think his audio is coming through that well. Would you agree?
I would agree. If there's an ability to get the audio amped up a bit, it would be helpful. And these sorts of stoppages are not going toward anybody's time. It's more important for us to get all the audio correct so that we can hear the witness.
Agreed, and thank you for that, Mr. Chairman. Okay, Jeff, we're going to do another sound check and then we'll start again, if that's okay. 1, 2, 3, 4, 5, please.
1, 2, 3, 4, 5.
I think that's a little better. Just remember to try to project and not tail off at the end of your sentences, if you would.
Yes, sir.
I'm ready, I believe, Mr. Chairman.
Go ahead.
You state your name and current employment position.
Yes, my name is Jeff Peterson. I've been employed as a roustabout supervisor for KP Kaufman.
How long have you been employed by KP Kaufman?
About 16 years, a little over 16 years.
And very briefly, what's your education background?
I have a high school degree and I have some college background, or I have some college in construction management.
Construction management?
Yes, sir.
What other experience do you have besides with the KP Kaufman Company?
I grew up as a rancher, a son of a rancher in Wyoming. We managed cattle.
Okay. Thank you. So 16 years with KP Kaufman, you must have a lot of experience with the type of wells and flow lines and consolidation flow lines that KP Kaufman operates?
Yes, sir, I do. I believe I do.
And as a roustabout supervisor, are you responsible for responding to spills or releases, doing repairs and upgrades?
Yes, sir, I am.
what operator originally put all of this production infrastructure in, the wells, the flow lines, the consolidation flow lines that KPK primarily operates?
I believe it was Amoco.
And do you know about when that those wells and those flow lines and consolidation flow lines were installed, just roughly?
Roughly in the 80s, some in the 70s.
Okay, thank you. What's the difference between a flow line and a consolidation flow line in this network that you're a roustabout supervisor for?
The difference between a flow line is that the flow line transports the material from the actual well to our header system. And then our consolidation system is from that header system to the actual tank battery.
So the flow line, oh, I'm sorry, go ahead.
It gathers multiple flow lines.
So flow line, as you're referring to it, is a single wells production?
Yes.
And a consolidation line is multiple wells production?
Yes.
And is this single phase production or three-phase production?
It's three-phase, both oil, gas, and water.
All together, not separated at the wellhead?
Not separated at the wellhead, no.
Do you have an understanding as to why this system was developed that way?
No, I can't say as to why it was developed this way. Maybe for efficiency purposes, I don't know.
Okay, that's fine. In your position with KPK, have you had occasion to engage in consolidated flow line repairs and upgrades?
Yes, sir.
And did you supervise work on the UPR 43 consolidation line at issue in this NOAB?
Yes, sir, I did.
You mentioned the flow line headers. What purpose do those serve?
As a collection point prior to going into the consolidation line, and also as an isolation point.
An isolation point, is that a valve?
Yes, sir.
Like the one at issue in this particular NOAB?
Yes, sir.
And does that valve stop the three-phase production that flows into the consolidation line?
Yes, sir, it does.
Okay. What typically causes the failure of a steel consolidation flow line like the one at issue in this UPR 43 case?
In this particular case, there was a hole that had developed in the carbon steel.
And what's the cause of the hole developing?
It could be water, salt water in the bottom, just laying in the bottom of the line.
So is that corrosive? Did it corrode the steel?
It is salt water.
Okay. So did you just repair the hole in this case, or what did you do? What kind of repair was undertaken?
In this case, our repair was going to be to sting 6-inch poly pipe through the line on the south side of the road, on the south side of County Road 4, over past where the hole was to the north side of the leak site, and make our connections there.
How big is the steel consolidation line?
The steel consolidation line, I believe at that time, was 10-inch.
And you're saying you can sting, or what is that, like threading the poly pipe inside the steel?
Yes, we actually push the poly pipe through into the steel line, into the steel pipe, and the steel pipe actually acts as a sleeve for that.
What's the benefit of using poly pipe like that?
We found that it's non-corrosive, that it's less likely to leak.
Very good. You heard testimony of the staff witnesses earlier, in this NOAV regarding 2 excavations at this location, one on the north side of the road and one on the south side of the road. What was going on with the one that was not contaminated on, I believe that was the south side of the road?
That was going to be one of our points of connection. Once we had the poly pipe underneath the county road, that was going to be our point of connection on the south side.
So you'd be threading the poly pipe from one side of the road to the other and past the hole? Is that, am I understanding that correctly?
Yes, sir.
Okay. Has KPK done much of this kind of upgrading of consolidation lines with a poly pipe liner? Do you know?
Yes, yes, we have.
Oh, actually, let me back up. I want to share my screen and ask you to look at a picture. It's a picture in, Staff Exhibit 707, which is also our Exhibit G, I believe. But I'm just about to share that. And here we go. Bear with me. I believe that you should be able to see 2 pictures, but I want you to focus on the one to the left. Do you see that?
Yes, sir.
And so is that the poly pipe down in the ditch that is kind of going into the larger steel pipe that I'm looking at in the middle of that?
Yes, sir. Yes, sir, it is.
And if you look up close to the horizon across the road, is that a backhoe at your other excavation point that is where you were threading the poly pipe in from an uncontaminated point of entry?
Yes, sir. That's correct.
Okay, thank you. Stop share for the moment. Have you planned and supervised those kinds of upgrades for KP Kaufman in your position as a production supervisor or roustabout supervisor, excuse me?
Yes, I have.
And do you know approximately how many miles of line that KP Kaufman has upgraded in this way with this stinger or threading a poly pipe inside the steel consolidation line?
I would estimate a guess as to multiple miles. Yeah, many miles of pipeline we have done this way.
I am about to share screen again. Bear with me. Opening exhibits triple B through triple G, APK exhibits. But I haven't shared yet, so just hang on and then I'll scroll through them. Okay. I believe, can you see that?
Not yet.
Oh, I'm sorry. You got to hit share. Hit share twice.
And Mr. Jacobs, could you identify the which exhibit this is again?
Yes, these are multiple exhibits. I'm just going to zoom out for just a moment. And I believe you can see down at the bottom, triple F, General Exhibit triple F is this particular map. Do you see the highlighted lengths of flow line there?
Yes, sir.
And are you familiar with this diagram?
Yes, sir. I have seen it before.
And do you know who prepared it?
I do not know who prepared it.
Okay. We can cover that in a moment. That's triple F. We'll go to triple B. We have another diagram. Do you recognize some of the locations identified on this map?
Yes, sir, I do.
By well name, for example.
Yes, sir, I do.
Okay, and the highlighted portions, you've reviewed this, and is it your understanding that those are the lengths of consolidation flow line that have been upgraded using this stinger procedure?
Yes, sir.
Let me just click through real quick. We've got triple C. And triple D. And I believe we saw triple G. Here's the last one. Zooming out a little bit. Okay. Thank you for that testimony. Turning to the UPR 43 repair. Your roustabout crew first responded when to that location? I believe you heard testimony earlier that the landowner had notified you of a release. Is that correct?
Yes, sir.
What did you do when you arrived at the location to address that release?
When we address the release, the first thing I do is call in an emergency locate to identify any potential lines in the area so that we do not strike them. And then we proceeded with the cleanup, meaning trying to get the free product off the ground, and so that we can haul it to an approved landfill site.
Please remember to keep your volume up.
Sorry.
No problem. Do you then also locate the valve in the header that you talked about?
Yes, sir. We do.
And please describe what's done with that.
There is a valve that is an isolation valve usually in the vicinity, but in this case it was in the vicinity on both the downhill and uphill sides. My crew proceeded to go down into where the valve is and to shut that valve to both of them. And at that
How far
point,
away is that valve from the location of the leak?
I would say approximately 150 yards.
Okay. And you're aware, because you heard the testimony earlier from staff, that the commission has alleged that KPK failed to maintain the isolation valve upstream of the location of the leak in this consolidation line. You heard that correctly?
Yes, sir, I did.
Do you have any knowledge of any failure to perform functionality tests or otherwise maintain the valve in question?
No, sir.
Do you have responsibility, or who would have responsibility for performing those tests for KPK?
For performing the test, it would be Manuel Silva.
And what's his position?
He is the production manager for KPK.
Thank you. And are you aware if KPK has a valve repair and maintenance plan to which it adheres?
I know that we do put chemical in our wells that eventually end up into our consolidation lines.
Is that for purposes of their maintenance?
Yes, sir.
So would that go to the testimony earlier about preventing or reducing the likelihood of debris in the line?
I believe it would.
Do you believe that debris fouling an isolation valve would constitute a failure to maintain the valve in good working condition in your experience?
I don't believe it would be a failure of maintenance. Sometimes other debris can be in that line, and it could be just a random piece of like a stuffing box rubber or something like that. But as far as a failure to maintain, no, I don't believe so.
So turning back to your response to the original leak, you isolated the production using the isolation valve. What then did you do to address the release?
A vacuum truck would be attached to that line at a point, close to where the leak was. We have a blow down valves that we can hook a truck up to and proceed to evacuate the line.
Does that, what's the purpose of that?
That relieves the pressure off the pipeline and also removes as much free product in the pipeline as possible.
And is it your testimony that that was performed in response to the original notice of a leak from a landowner?
Sir. Yes, sir, it is.
And thereafter, did you witness or observe any hissing or leak of gas as described by the staff when they inspected the location on the 23rd of December?
At that point, I did not witness any gas.
Then after staff called in the gas leak, after hearing the hissing that they testified to, were you or one of your crews dispatched to the location again?
Yes, my crew had gone to our yard to load up supplies in order to bring back to location in order to proceed with the repair.
Did any of them report any hissing or evidence of a gas leak from their work on the other side of the road?
No, sir. No, sir.
And that was the crew that was getting HDPE pipe, I believe?
Yes, sir, it was.
And that's the pipe that would be used in the Stinger upgrade of the line?
Yes, sir. That's correct.
Okay. Were you dispatched to this location to depressurize the line after staff heard the hissing and the events that they described earlier unfolded?
We did dispatch a vacuum truck again, and I personally supervised the vacuum truck in hooking him up to the blowdown valve, and we proceeded in evacuating the line again.
And was there any precaution taken after depressurizing the line with the vac truck to determine if there were vapors coming out of the line?
We did just an odd physical inspection to see if we could hear any gas blowing out.
Did you?
I'm sorry.
Did you hear any gas coming out after depressurizing the line?
No, we did not.
Did you check the isolation valves as well?
Yes, we did. And they seemed secure.
Thereafter, did you see any free liquid product, produced water or oil coming out of the hole or
No,
the
sir.
line?
No, sir, we did not.
So no hissing and no liquid.
No, sir.
I believe that concludes my direct exam of this witness. Thank you.
Ms. Rosenberg, do you have cross-examination for this witness?
Just a couple, thank you. Do you know who the KPK was the operator of record for the flow line in September 2019, correct?
Yes, ma'am, that's correct.
And did you maintain any of the maintenance records for the flow line at issue here?
No, ma'am, I did not.
And did you say that you didn't observe an active gas leak on September 23rd when staff was there, COGCC staff?
When staff was on location, I was not on location. I was not per se at that location. I was helping the truck get hooked up to the blowdown so that we could isolate that. And when I show up on location, I am currently busy calling in emergency locates so that my crews can begin the cleanup process.
So did you say you had never heard the gas leak?
No, ma'am.
You didn't hear it?
No, I did not hear it initially.
Okay. Do you deny that there was a gas leak?
No, I do not deny it.
You just don't have the firsthand knowledge because you weren't there for it. You weren't with staff.
Not in the immediate location, no.
Okay, thank you. Those are all the questions we have. Thank you.
Mr. Jacobs, any redirect?
A redirect, Mr. Chairman. Thank you.
Okay. Looking to fellow commissioners, if anyone has questions. Commissioner Nanjapa?
Thank you, Mr. Chair, and thank you, Mr. Jacobs, and thank you for the testimony, Mr. Peterson. I am not sure I heard of this, but I believe that Mr. Jacobs asked specifically, when did KPK first respond to the release complaint, but I did not hear of the specific date. Mr. Peterson, could you respond to that?
I don't have the specific date in front of me. I would need to check my notes.
Okay, and then as a follow-up, I think my understanding was that based on this, the last bit of questioning, that you were not directly present at the site at the time that that COGCC staff was there on the 23rd. But is that correct?
That's correct.
Okay. And do I understand correctly then that you were, or could you tell me then, if you do not recall the exact date that you had responded to the incident, approximately when in relation to the staff being present did that occur?
I'm sorry, could you rephrase that?
The staff was there on September 23rd. You said you were not present at the time. And you said you do not recall the date that you responded to the release complaint. I'm just curious, can you give me an approximate time frame of when you think that occurred, that you began to respond to this? Was it before, several days before, a day before, 3-4 days before?
When staff was on location, I was in the general area, I believe, hooking up or helping hooking up the truck to evacuate the line. And so the response would have been, I guess you could say, within the hour of KPK being notified. At least when I was notified, I dispatched people immediately.
And thank you, Mr. Peterson. And so do I understand correctly that you're referring to when KPK was notified by COGCC staff, by Mr. McLaren?
Yes, ma'am.
Okay. Thank you.
Mm-hmm.
Commissioner McGowan?
Thank you, Mr. Chair. And thank you, Mr. Peterson, for this information. I'm wondering if you could tell me how it typically works when you go out to make a repair. Is it usual to check in the next day or the next several days to make sure that the repair was complete or that it's been successful? How do you know that your repair is done, and what kind of follow-up is typical when you make a repair?
Are you speaking as to how do we know the repair is working? If the repair works, is that my understanding?
Yes, sir.
After we complete our repairs, we do a pressure test on that line prior to any backfilling or any covering of the line.
Commissioner McGowan?
Thank you, Mr. Chair. So in this instance, there was the leak, and you all came out to check on it and started working on, I may be not understanding the sequence of things. The solution was to insert the poly pipe in the 10-inch pipe. Was there something done in the interim? Because obviously you couldn't stick the pipe in right away. What was done immediately to plug up the hole so that it wasn't leaking when the complaint was first sent by the owner?
Are you speaking to when the leak first happened, or from when staff showed up on location?
When it first happened.
When it first happened, the only thing that we really could do is to contain any free product that would have been on the ground, and also evacuate the line. That's pretty much the only thing we can do at that point to cease any more product from coming out.
So was that the vacuuming?
Yes, yes, ma'am.
Okay. And then sorry, I'm just trying to understand.
No,
when you vacuumed, then was something plugged on either side of the hole so that something wouldn't keep running through the hole until you could come up with the pipe?
We had isolation valves.
Isolation valves.
Sides.
Okay.
Yes.
Thank
yes,
you.
ma'am.
Now I'm understanding. Thank you.
Commissioner Messner.
Thank you, Mr. Chair. Just a couple of questions. So when I read the pre-hearing statement from KPK regarding the activity around this this leak, and that there was activity on the south side and on the north side, and it clearly indicates that on the south side there was at no times any repairs happening, and that it was a completely separate activity and was not related to the repair of the leak that was on the north side. Mr. Peterson, what I'm hearing you say is that the activity that was on the south side was actually directly related to what was occurring on the north side and was very much an attempt to repair the situation. Is that correct?
Yes, sir, that's correct. The excavation on the south side of the county road was related to the actual, that's how we were going to fix the pipe. That's how we were going to fix the line. That was going to be our initial sting point for our poly pipe.
Okay, thank you. One other question. Mr. Jacobs had asked you a specific question about your knowledge of maintenance plans. I don't think you actually answered that question. So to your knowledge, does KPK have maintenance plans associated with these types of flow lines and isolation valves that they follow?
As far as a maintenance plan, no.
Okay,
not that
thank
I'm
you.
aware of.
So I've got one follow-up question, and Mr. Jacobs, this may not be within this witness's factual database. I just don't know, but I want to ask the question now because he may be the right witness. But so you did ask the question, Mr. Jacobs, of your witness, when did they first respond? And the witness actually did not answer that question. He said, we called it an emergency locate, we ID the lines in the area, then we locate the valve in the header, we locate the isolation valve, and then later they go in and do a vacuum. That's just a rough summary of my notes from the witness, right? But KPK learned of a spill on September 19th, and they reported the spill on September 20th. Does this witness have any information about what KPK did on September 19th when they learned of the spill, or any information relevant to what KPK did on the 20th when they obviously, someone must have gone on site to figure out what was going on? And again, I don't know if this witness is the witness to ask that question of, but I'm asking it anyway.
You're asking that of me? Or,
no, I'm asking it to the witness, I guess.
Okay. Well, I can tell you that our next witness will answer many of the questions that have been answered or raised by commissioners, including this one. And that's Mr. Max Knopf, the environmental manager who submitted the forms. I was not aware that Mr. Peterson didn't recall his activities on the 20th or identify them any more specifically, but I believe Mr. Knopf would tie this all together.
Okay, well, let me just exhaust this witness's factual understanding.
Absolutely.
Do you have information about KPK's response on the 19th when it first learned about this from the surface owner, or any activity that occurred on the 20th in doing an inspection out there to see what was going on?
Yes, upon notification, when I received notification that we had this release, I dispatched a roustabout crew to that area in order for us to contain any free product on the ground. As far as a timeline, when I received the notification, I immediately notify my crews and dispatch my crews.
And that would have been on the 19th when the landowner told you about it?
Yes, sir. Yes, sir. That's correct.
And do you know what your crew found?
We found free product on the ground, oil, combination of oil and water. And that's when I showed up on site shortly after, that's when I began to do my emergency locate so that my crews would be able to safely dig around and contain the mess.
And so when they got out there, they saw free product on the ground, but there obviously wasn't a hole there anymore because you hadn't dug down to figure out where the problem was. Is that right?
That's correct. Yeah, we had not dug down yet.
Okay, and so when did you first dig down that would have exposed the pipe that was allegedly hissing?
I don't have my notes in front of me, but I do believe it would have been the following day. Once we got things contained and the line blown down, we would have begun hauling off the contaminated soil and also digging down on the pipeline the following day.
And were you on site for that digging down the following day, which would have been the 20th? Or is that the next witness?
I don't recall being there on site. I may have been called to other locations that I'm responsible for, but I do recall seeing the location.
When?
It would have been the following day when the crew initially started digging down.
And do you have information about what the crew found when it got to the line?
Yes, when the crew found the line, and after cleaning out and inspecting the line, we did notice that there was a hole in the carbon steel in the bottom of the pipe.
And that's where the leak was occurring of the three products?
Yes, sir.
And what is the standard of care, I'm using that word loosely, for something like that? Do you leave it leaking and then a few days later bring in your vacuum truck, or what?
No, sir. No, sir. At that time, we did not see anything leaking out of that pipe at that time. It was, and if we had noticed anything leaking, we would have immediately brought the vac truck back over and evacuated the line again. I would ask the crew to, let's back away and let's re-evacuate the line.
Do you have any thoughts on what happened between the day of the 20th when you exposed the line, found the hole and it wasn't leaking, and the 23rd when it seems like everybody stipulated that it was leaking?
As far as thoughts, I don't. When I was notified that we had that it was emitting gas again, after I found that out, I immediately called up my foreman, my pusher, and told him, let's just stay clear of the area, or stay clear of that hole until we can get the vac truck back over there. And at which point we made we notified for the vac truck to come over and re-evacuate that line again.
Commissioner Joppa, I see you have your hand up.
Thank you, Mr. Chair, and thank you, Mr. Peterson. I think we're all trying to understand this timeline. It feels like there's been a couple of different things you've said that aren't lining up, at least for me. And this was my question previously was, what was the date that you first responded? It sounded that you told me that it was when our staff on the 23rd, Mr. McLaren, had called KPK that's when you responded and that's when you brought the vacuum truck out. But now it sounds like you're saying that that was the second time that you came out with the vacuum truck, and that there was free product that you observed at least the day after it was reported by the landowner, and there was some activity that was done then upon excavation. Can you just clarify that for me, the timeline of events as you understand when the landowner reported it and then when our staff came out a few days later?
Yes, ma'am, I apologize. So I guess the timeline would be the initial leak, which a vac truck was called out at that time. That would be the first time. And then when staff notified KPK about a gas leak, then we brought the truck out again to evacuate that line. So the truck was out twice to evacuate that line.
Sorry, and then thank you. To follow up then, so upon that first visit with the vac truck, the reason you had the vac truck was because of the leak that was reported by the landowner. And it sounds like at that time, that was when you observed the free product on the ground?
Yes, ma'am, that's correct.
Okay. And then, let's see. And I believe we had, I think we have also in KPK's pre-hearing statement that as one of the facts in dispute, that KPK denies that its field crews were performing or attempting to perform any work within the excavation area. It sounds like you were doing that at the time. Is that what is correct here?
When the crew came back to location, they were on the south side of the county road. They were in the process of unloading because we were also using that side. We gained permission from the landowner on that side to use as a staging area too, for us to put our equipment and put our material. And it was within the vicinity of the southern hole, the southernmost hole, the one without the contamination in it.
Commissioner Messmer.
Sorry, I just wanted to just wrap that up. So just to understand, just make sure I'm understanding correctly, is that so upon the landowner reporting, then by the second day you were out there with the vacuum truck, there was excavation that occurred then. This was all related to the leak, but the goal was to use the south side to be able to reconnect to the north side in order to address the leak. And so therefore the excavation and the repair work that was occurring on the south side was related to this whole event. Is that correct?
It was part of our repair process, yes. And probably just to clarify, the vac truck would have been out there on September 19th. The vac truck was not, we did not bring it out the second day after the leak was reported. That the vac truck would have been brought out, or was brought out the day that we were reported, that the landowner reported it to us, so that we could evacuate that line at that time.
And you were on site at that time for that with the vac truck?
I was with the vac truck. The actual blowdown point is some distance away from the actual leak site.
Okay, and I appreciate this. There's been some time that has passed, but your statements are a little bit in conflict with each other. You had said the report happened, then the day after was when you came with the vac truck. Now you're saying it was the same day.
No,
we're all just trying to understand the time frame here.
No, the vac truck would have come out on the 19th, as well as my crew would have come out to contain the leak site. The following day would be when we began the excavation of the pipeline. So on the 20th, it would have been, we would have excavated the pipeline, but the truck would have come out on the 19th in order for us to evacuate the line and depressurize the line. And then subsequently, when staff was out on location and heard the gas leak, we brought the truck out again at that date.
Okay, I appreciate that clarification. And so it sounds like when you were out there with the vac truck and depressurizing the line, that was also when you observed the free product, and that was what led to the excavation.
Yes, ma'am.
Okay, thank you.
Commissioner Messner, do you still have a question?
I do, Mr. Chair. Thank you. Just a quick question. You had indicated that during that excavation on day 2 that you removed some amount of contaminated soil that had free product incorporated with it. Where did you remove that to?
We had a dump truck come over and we were loading the truck, trying to load the truck as we were excavating. And that dump truck would have hauled that to the Front Range landfill.
So there is documentation of that going to the Front Range landfill?
Yes, I believe so. There should be.
Okay, thank you.
Further questions from commissioners for this witness? Commissioner Nanjapa.
Thank you, Mr. Chair. This is a separate matter that I just wanted to get some clarification, please, Mr. Peterson. You were mentioning about the chemicals that are put into the pipes to prevent debris, I think is what you responded to Mr. Jacobs's question. Are those chemicals primarily for like anti-corrosive properties, or can you just explain a little bit more about what types of chemicals are put into the pipelines and how they work?
I guess I should say I'm not an expert on the chemicals. I just know that there are scale inhibitors that are added to the wells generally during workover, and those chemicals eventually make their way down the pipeline to the consolidation line and eventually to the tank battery.
And the purpose of those, as you understand it?
To my understanding, it is to help minimize scale on on the tubing and the pipelines.
Does that scaling contribute to? Can it contribute to the potential failure of the valve?
If a small chunk could break off and go down the pipeline, there's the possibility of some fouling of the valve.
Okay. Okay. Thank you.
Other questions? All right, Mr. Jacobs, I believe we can allow this witness to be released.
Mr. Chairman?
Yes.
Am I allowed some limited redirect?
Sure.
Thank you. Mr. Peterson, at the time of the staff's inspection, the south excavation on the other side of the road, was the pipe opened yet, or were you just exposing the pipe to gain an access point for when you took the poly pipe to make the upgrade?
The pipe was not opened up yet. It was not cut.
If it had been opened up, gas would have been leaking over there if the line was pressurized as well. Is that true?
That's correct.
but it hadn't been opened up. The only leak of which you're aware was in the north excavation, the one that staff described earlier in their testimony.
Yes, sir, that's correct.
About how far, again, is the location where the workers were unloading HDPE pipe to work on the south side once
Mr.
they
Jacobs
entered
was
the pipe?
testifying for his client.
I'll rephrase.
Thank you, Mr. Jacobs.
How far away was the HDPE pipe being unloaded, do you recall, from the north excavation?
From the north excavation, it would have been approximately 100 yards.
Very good. I have no further questions on redirect.
Okay, great. Let's move on to your next witness.
Thank you. KPK calls Max Knopp. Thank you, Mr. Peterson.
Mr. Jacobs, you're muted.
Oh, I'm sorry, I'm muted temporarily. Good afternoon, Mr. Knopp. Could you please state your name and current employment?
Yeah, my name is Max Knopp. I'm Director of Environmental with KP Kaufman.
And I'll just remind you to please try to project. You're audible, but could be a little louder. So thank you.
Okay.
Great. How long have you been employed by KP Kaufman?
I've worked for KPK for 7 years.
And prior to that time, with whom did you work?
I had a little over 2 years. I worked as a consultant with Lissair Environmental.
Very good. And briefly, what's your educational background and any professional licensing?
I have a bachelor's degree in geology from the University of Colorado.
Great. With respect to the UPR 43 consolidation line that we've been discussing, this is based on a staff inspection of an ongoing consolidation line repair. Is that your understanding?
That's correct.
And this repair was necessitated by a release reported by the landowner. Is that also your understanding?
Yeah, that's correct. It was reported on the September 19th.
Great. How did you learn about it?
The landowners contacted KPK and the information was relayed to me regarding the release.
And what did you do in response to that information when you received it?
It was KPK was notified company-wide, so the appropriate people were notified. So the crews were personnel was dispatched to resolve the observed release by isolating that section of flow line. So I would incorporate both the upstream and downstream isolation valves from that release point. And then I believe a vac truck would have been brought in to depressurize that isolated section of line, and initial excavation to scrape surface impacts would have been done.
Who's responsible at KPK for filing the Form 19 spill and release report associated with the original release that the landowner reported?
That would be myself.
And when did you submit that?
It was September 20th.
And did KPK respond prior to the submission of that form to the notification of a spill or release from the landowner?
Yes, so those initial field activities I previously explained, those were conducted on the 19th.
And that included closing isolation valves to stop any release?
Yes, that would have been the initial step to take to isolate that release.
And from that point forward to the completion of repair and the pressure testing that Mr. Peterson described, were those isolation valves open to your knowledge?
No, not during, no, since they've been closed, they have not been open.
So to the extent there was any free product in the bottom of the excavation, was that from the initial leak, to your knowledge?
Yes.
Okay. Now, turning to the events of the 23rd and the prior testimony you listened to of staff related to their observations that day during their inspection, how did you learn of that inspection and the report of an active gas leak?
On the 23rd, Mr. Joe McLaren, I think, was doing a follow-up inspection of the reported release location, and he had contacted me regarding an observed active gas release occurring at the location.
So you got the first report of that among all other people in the company by getting a call from Mr. McLaren. Is that your understanding?
That's my understanding. The information was spread to the company once I was notified.
Right. That was my next question. So what did you do in response to that call?
I contacted our production supervisor, Mr. Manuel Silva, let him know about what I was just informed of, and then we agreed to meet at the location to assess the situation.
And how long did it take you to meet Mr. Silva at the location?
It was approximately about an hour upon notification to meet there.
And were other KPK personnel at the location when you arrived?
No.
Okay. Approximately, oh no, we've covered that. Oh, we've covered that, sorry. Did you observe the hissing sound that staff reported when you arrived at the site with Mr. Silva?
Yes, it was an audible leak occurring.
Staff described this as a massive gas leak. Would you agree with that characterization?
No, I wouldn't have a way to quantify the gas leak with available resources, and based on the audible sound, I don't believe it would qualify as massive.
Thank you. After the line was depressurized, as described by Mr. Peterson, following the report of the active gas leak, did you evaluate whether or not there were vapors coming out of the hole in the line after depressurization?
Yeah, so we had to have a vac truck come in on the 23rd because of the repressurization of the line. And so once the vac truck connected and was able to blow down that section of line, I went back to the excavation area and made a IR camera recording of that area.
I am going to try and share with you that IR camera recording. Yes, Zoom ought to help. I'm going to share a screen. To maximize that. This is Exhibit Y of KPK. You recognize this video?
Mr. Jacobs, we don't see your screen.
Oh, I'm sorry. I didn't share a second time. We'll do that again. It's a very short video clip. Thank you so much, Mr. Chairman. Old lawyers and high tech, bad mix. Let's try that again. So we're looking at KPK Exhibit Y, as it's shown at the bottom of the screen there. Can you see that?
Yes, I can see that.
And based on your experience with an IR camera, and I'll just click that a couple times so you can scan it again. What are you doing there with the camera? Scanning.
I'm just scanning the length of the exposed flow line there. So I'm on the north end of the excavation. You can see that, I don't know how to describe it. It looks like a conduit or collar, that larger diameter at the top of the screen. That was the leak point. So I'm just reviewing with the IR camera to make sure there's no vapor present in the excavation area.
And did you see any vapors escaping based on your experience with IR camera from that length of line after the depressurization on the 23rd?
No.
And did you provide this video to staff?
I I gave a notification to Mr. McLaren about having the IR camera recording and letting him know that the active gas release was resolved based on that recording. He had mentioned he did not need a copy of that recording, but to keep it on file.
Very good, thank you. Now, a day or two later, Mr. McLaren called you again, did he not?
Yes, that's correct.
And what did he have to tell you?
He was doing another follow-up of the location, and during that inspection, he once again observed an audible leak from the flow line.
And did he examine it with an IR camera as well?
Yes. Yes, so it would have been a visual of the leak as well, not just audible.
Okay. And what did you do in response to that information?
I relayed that information to our field operations. They once again dispatched a vac truck to depressurize that section of flow line. I followed up the following morning with an IR camera and made a recording to show that the line had been, or the pressure issue had been resolved.
And then what steps were taken thereafter to prevent the line from further repressurizing?
Based on, the occurrences, right? We've had 2 pressurization events that have occurred. So it was an understanding that with the isolation valves, that was not operating correctly. So once it was depressurized, we knew we had to go in and install temporary isolation valves to resolve the issue permanently.
And I believe staff testified to that as well. Did you also use bull plugs on the open ends of the temporary valves?
Yeah, so we connected, I believe there are 3-inch ball valves, and then to the each side of the flow line, and then to the other side of the ball valves, bull plugs were installed as well.
That was extra secure from any repressurization?
Correct.
What do you understand the cause of the repressurization to have been?
Based on what we know, right, we have an upstream and downstream isolation points, really nothing in between. So our determination was there was some issue with an isolation valve.
And did you respond promptly, or how do you feel that you respond timely to Mr. McLaren's calls in each instance?
Yes, I believe so. An active gas release is a serious event, so we immediately responded.
You believe that in each instance you corrected the condition as soon as possible?
Yeah, I believe we responded and corrected as soon as possible and as best as possible.
And did you immediately control and contain the spill in the first instance when reported by the landowner?
Yes, so when we initially responded, they had contacted us with the observing fluids that were daylighting on surface. Once we isolated that section of line, the fluid activity stopped on the surface and no additional pressurization was observed.
And do you believe that you took reasonable precautions to protect against environmental impacts?
Yes.
With respect to the original spill?
Yes, that's correct.
And then with respect to your response to the gas leak?
Yeah, we responded as quickly as possible to each event.
And did you do you know if the completion of the upgrade to the line from the south side of the road up to and past the leak in the north side of the road, was that completed?
I don't know that for sure.
Okay. We can ask Mr. Silver perhaps. Finally, with respect to the alleged Rule 907A violation concerning properly storing e-waste, have you seen staff exhibit 705 I believe they showed it during their testimony. There was a contaminated soil pile. I'll pull that up if you'll bear with me just a moment.
Okay.
Thought I had it. Sorry. Here we go. And share, click twice. Can you see that?
Yep.
If you let me scroll down a little bit, can you see a timestamp on that?
Yeah, September 23rd, 2020. Oh, I'm sorry.
What time of day?
2:02 p.m.
Yeah, and do you see the looks like a piece of heavy equipment by my cursor upper right?
Yeah, that's the backhoe that was used for the initial excavation.
Is it your understanding that crews were actively working at the time of this photograph?
Yes. So my understanding is that they were working in, earlier in the day, excavating. What is shown here, we have impacted soil.
Can they be working actively with a backhoe, placing soil like this with berms in place without breaching those berms or moving them?
No, it's not our procedures to install berms during active excavation.
When are they installed?
Our policy is to install them at the end of each day.
Okay, so this picture does not, well, do you believe this picture is conclusive evidence that you did not employ berm best management practices to prevent stormwater runoff from this pile at the location?
No, only because it was taken in the middle of the day, so it wouldn't have been at the completion of the day.
Right, very good. I believe that concludes my direct exam of Mr. Knopp. Thank you.
Ms. Rosenberg, do you have cross-examination?
Yes, thank you. I do have a few questions. Thank you. Mr. Knopp, on the 19th, did anyone confirm that the valves were holding the pressure? And if so, how?
It would only be a visual confirmation that the valves were in a closed position.
And when was that video taken, the exhibit Y that looked at?
That was taken on the 23rd, so that was at the conclusion of the day, following Mr. McLaren's observance of the active gas release. KPK getting the vac truck on location to complete depressurizing that line, and then that IR camera video was taken as a follow-up inspection to confirm that the vac truck successfully depressurized the line.
Thank you. And then on the 20th, what did KPK do to ensure to check to see if the valves were holding the pressure?
It would have, we had that visual confirmation that the valves were in a closed position, and there was no evidence that there was any kind of repressurization or pressure issues associated with that section of flow line.
And that was on the 19th?
No, that would have been on the 20th or following the 19th when the release occurred. And then, when crews were on location to begin remediation work.
What did KPK do on the 21st to make sure that the valves were holding the pressure?
Again, the valves were already confirmed to be in the closed position, and there was no indication that there was an issue with the isolation valves. There was no observation of, releases, liquid or gas. The section of flow line seemed to still be isolated.
Let me ask this a different way. Did KPK go out on the 20th to confirm that the isolation valves were holding the pressure?
I'm not sure if they did a visual confirmation of the valves on that date, but there was no indication that that would be necessary.
Did KPK go out on the 21st to ensure that the valves were holding the pressure?
No, for the same reasons previously provided.
And did KPK go out on the 22nd to confirm that the valves were holding pressure?
Mr. Chairman, I'm going to object to this line of questioning. I think she's badgering the witness. I think I see where she's going. And he's answered that the valves were in the closed position and there was no other reason to indicate they needed to be rechecked.
Did KPK go out anytime between the 19th and the 23rd?
No, there was no observed issue with pressure on those dates.
And did the valves actually hold the pressure?
To our knowledge, they did until the 23rd when the active release was observed.
What kind of pressure is typically found in the flow line?
I'm not positive, but I believe the operational pressures range from 20 to 40 pounds.
And did I understand you to say that the temporary valves resolved the issue permanently?
Well, it resolved the active gas release, yes.
And then was that all that was done to permanently resolve the issue?
I believe more functionality was done on the valves to attempt to clear out any debris that may have been preventing them from functioning correctly.
So is that the temporary valves that are still installed?
Yes.
What is the difference between a temporary and a permanent valve?
They were installed just for a temporary time period.
From September 2019 until present?
No, until we can verify that the isolation valves, the permanent valves, were operating correctly.
And then you noted that there was an issue with the isolation valve. What was the issue?
We believed it was debris within the flow line that was prohibiting the valve from properly closing.
Actually, can you repeat that answer? I didn't hear that very well.
We believe there was debris within the flow line that prohibited the isolation valve from properly closing.
Thank you.
Did you confirm that or you just believe that?
No, there is no way to look inside the valve.
So you don't know definitively that it was the debris?
No.
And so you believe you did everything you could to minimize the adverse environmental impacts, correct?
Correct.
But was gas still released?
When?
On September 23rd and on September 19th, 2019?
Yeah, on the 19th, production fluids, oil, water.
2020, excuse me, sorry.
No, I don't believe there was any release on the 20th. Is that what you're saying?
All right, okay, I understand what you're saying. And did I understand you to say that on the 23rd, when we were looking at the pile of impacted soil, that you said it was during active excavation?
Based on the photo, it looked like it was a product of active excavation activities. Yes.
So was a crew doing active excavation on the 23rd?
Yes. The photo seems like there potentially was activities being performed there.
And when were they doing that?
That would have been in the morning prior to my arrival at the location. When I arrived, there were no crews on site.
Okay, thank you. Those are all the questions I have.
Mr. Jacobs, do you have any redirect?
Yes, thank you, Mr. Chair. The crew delivering HDPE pipe to the south excavation at the time staff was there on the 23rd, Mr. Knopf. Were they also responsible for any of the work, at the leak location on the north side?
No, the crew that arrived following my arrival at location, they were just there to go to the adjacent field in the south end of County Road 4 to drop off that HDPE pipe.
Okay. You heard staff testify that near miss is a term that's not defined in their regs. Do you agree with that?
Yeah, I agree with that. After being provided guidance on filing a Form 22, an accident incident report based on the occurrence of a near miss. I went back and reviewed. There is no reference to a near miss in any of the rules or regulations.
And you also saw in staff's testimony pictures of the excavation very recently that show it's still open. Why is it still open to your knowledge?
We are having excavation issues on the south side. We have encountered an active irrigation line that is contributing to the water collection that is causing delays in excavation activities, but we're also we're at a point during excavation where we believe confirmation samples could be collected. I believe that was done on July 30th. The COGCC was notified about that sampling event, and that was
very good. Excuse me, I didn't mean to interrupt. You saw staff's recent pictures of the open excavation?
Yes.
During their testimony?
Yes.
And you also then saw the water in the bottom of the excavation with the exposed pipe?
Yes.
Is that the irrigation line water that you talked about just a moment ago?
There is groundwater present in that excavation, but a majority of the water is contributed to the irrigation water coming from that pipe located on the south side of the excavation.
And then lastly, you mentioned confirmatory sampling. Could you explain what was being sampled and what the purpose of that was?
We were just sampling the soil, so we had sucked out the water in the excavation in preparation, so we were able to access the excavation location for soil sampling. And we were trying to establish points along the excavation walls and floor of the excavation to collect samples to confirm that they were in compliance with the Commission's 915-1 table of thresholds.
And have you gotten the results of that sampling?
We just recently received those results yesterday.
And what generally is your understanding of those results?
Upon initial review, the sample locations that we collected from appear to be in compliance. However, we did not sample the south wall because we know there's still existing contamination along that portion of the excavation area.
Very good. I have no further questions.
Looking to fellow commissioners, if anyone has a question at this point for this witness. Commissioner Gonzalez.
Thank you, Mr. Chair. And I just have a clarification question. I think I heard you say that there wasn't or there isn't a way to observe debris in the valve. Did I understand that correctly?
Yeah, without actually disconnecting the valve from the flow line and looking inside it. But from an outside perspective, there's no way to verify, what's inside that valve.
So was it ever verified that there was in fact debris inside that valve?
No, that valve remained installed and in place.
So it was kind of just an assumption that there was debris and that's why the temp valves were installed?
Yeah, mainly because we only had those 2 isolation points. And we knew even with those isolation valves closed, we had multiple occurrences of repressurization. Our only option was to install temporarily new valves to create additional isolation.
And then a question about that repressurization. Is that something that occurs normally? With what frequency? Like how often does a line that's been, vac or had a vac truck come visit and been depressurized, how often does it repressurize?
My time at KPK, this is the first instance of this issue.
Okay. That's all I have, Mr. Chair.
Commissioner Najapa.
Thank you, Mr. Chair, and thank you for your testimony. Mr. Knopf, I had a question related to what Commissioner Gonzalez just asked. So I believe in the cross-examination from Ms. Rosenberg, she asked if the temporary valves resolved it permanently. And I believe you said that those temporary valves were just temporary and they have since been removed and you had done some more functionality to determine that the permanent valves were operating. Can you elaborate on that?
Yeah, so once the temporary valves were installed, we knew that that release point that was observed to have that active gas release had actually been isolated. There was no further issue with that, but that also allowed us the opportunity to perform additional functionality tests on those isolation valves in an attempt to remove the estimated or theorized debris in those valves. And so once those temporary valves were then removed, we were able to confirm, well, one, the full line repair had been completed. I'm sorry, the pipe had been stung to those new isolation valves, so that release point on the flow line where the gas release was observed was no longer existent. It had been repaired with HDPE pipe.
Thank you. And when you mentioned that the additional functionality was done, and that once confirmation of the permanent valves operating correctly, then you had no reason to believe that there was any debris or further issue. When was that done? When was that confirmed?
I don't know that date.
Can you give an approximate time frame from when the temporary valves were installed?
No, I can't. I know we had routing of line issues. We had to put the new section of flow line realign it, I guess, to prevent it from going to the nearest property owners under his property. So for safety, we rerouted that line. So there were some delays working that all out. So I apologize. I don't know the timing.
Okay. And so per what you said with the threading of the poly pipeline, so are you saying that the valves that failed are no longer in use?
No, they're in use and they're still closed.
Okay. But you are not able, per Commissioner Gonzalez's question, you're not able to confirm whether or not there is still debris or whether there is any issue with those valves?
That's correct. They're in the closed position, and this location is associated with the director's order, and it's remained shut in.
Why was there a decision not to replace the valves?
I don't know. It was believed that it wasn't the valve itself that was the problem. It was the debris within the line that was the issue.
But you weren't able to confirm whether or not there was debris.
That's correct, but it was our best estimate as to the issue. So resolving the debris made more sense than replacing the valve.
Okay. One other follow-up question, if I may, Mr. Chair. Okay. There was the separate issue of the excavation that was present on the 23rd in that photograph, and your comments that this was an active excavation. We heard from Mr. Peterson that some of that excavation had occurred on the 20th. So was that occurring all the way through the weekend? Was it open throughout? Was it hauled off that day? And do you have the records of that?
We would have records of when activities were being performed at the location. I don't know if the activities were being done over the weekend.
So when that excavation occurred the day after the first leak was reported by the landowner, what then happened with those soils, and how did that relate to the soils that were observed in the photo on the 23rd?
Those photograph, that soil pile in the photograph would have been brought to certified disposal landfill, most likely the Front Range landfill.
But what I was asking is, there was the excavation on the 20th that occurred. So how was that addressed, or when was that addressed, and how did that relate to this soil pile that was observed on the 23rd?
The excavation is still ongoing, so that's still open. It's grown in size since that photograph was taken. That soil pile observed was removed from location and disposed of.
And that was sometime after the 23rd that it was removed from the location?
Yes.
And that included what was excavated on the 20th?
Yes.
So it was all one haul. It did not occur in multiple hauls.
I don't know the dump truck activity on those dates. I would have to look
You
at
have
the
record of that.
Yeah, we'd have disposal manifests that show the dates impacted soil was brought from the Uber 43 location to the disposal facility.
Okay, thank you.
Commissioner McGowan, then Commissioner Messner.
Thank you, Mr. Chair. Thank you for your testimony, Mr. Knopf. So now I think after Commissioner Njapa's questions, I'm maybe a little more confused. So is the contaminated soil pile all gone now from the north side, but still exists on the south side because you're dealing with those ground irrigation and groundwater issues? I'm having trouble understanding if the soil pile still exists or does not exist.
No, the soil pile doesn't exist, but within the excavation area, the south wall is still known to be contaminated. And we are having challenges continuing excavation activities because of an active irrigation line there, as well as other utilities and the county road at the south end of the excavation.
Okay, and maybe Commissioner Njapa was trying to get at this, and maybe there was a response, but I'm not sure I caught it. When was the soil pile removed from the north side and taken to an appropriate landfill?
I would have to look at disposal manifest that would align with, obviously the photo was taken on September 23rd, so we can look at disposal manifests from that location and how they correlate to those dates.
Thank you.
Commissioner Messner.
Thank you, Mr. Chair. Just a couple of questions. I want to talk a little bit about best management practices, or ask a question about best management practices associated with E&P waste or contaminated soil. So my understanding is that the reason that you create berms around a area of contaminated soil or E&P waste is because it is part of a stormwater management system. Is that correct?
That's correct.
And is it possible that it would rain or create a storm-like situation that could cause contamination outside of an excavated area during times of active excavation?
Yeah, that's always possible.
And so, in fact, the idea of actually having berms around an E&P waste situation and incorporating best management practices does not mean that you necessarily remove those berms during the day when you could certainly have a stormwater management situation, but rather keep those stormwater management BMPs in place the entire time that you're working with E&P waste. Is that not correct?
That's correct, but that also comes with the judgment of the field crews, observing the weather in the area, what their activities on location are going to be, how they're if they're going to need to exit the location, and how they're going to exit the location. I think if you could look back from that photo from September 23rd, I don't believe that it looked like there was any weather in the area.
I don't know. That picture that I saw only pictured the ground, so I couldn't tell you what the weather was. But so if I asked your peers across the state what best management practices are for berms in E&P waste management situations, they would agree with you that berms are not necessary when you're actively excavating on a site?
I can't speak to that.
Okay, fair enough. only other question I've got, well, two questions, sorry. And I think I was just confused. You had indicated that there was 2 pressurization events. What are those 2? My understanding is that there was only 1 pressurization event that included what you're alleging to be a debris in the isolation valve.
Yeah, so the first one was on September 23rd. That was the initial one that prompted, the grade 1 gas leak report. That was the initial observation. Mr. McLaren's follow-up inspection, I don't know if this date's accurate. I best estimate, I believe October 1st was the second event observance.
So the activities or the fix that you put in place on September 23rd failed again, which created a pressurization event on the 1st of October?
Yeah, we were only, and it aligns with, the grade 1 gas release. We were having to do continual work. There was no solution at the time. We were constantly having to bring a vac truck to location, daily monitor the line to see if repressurization had occurred.
And just to make sure that I understand too, because in KPK's pre-hearing statement, there was a clear indication that the root cause of this was not an isolation valve, but rather an isolation gate valve. I don't know what the difference is between an isolation valve and an isolation gate valve, but it seemed to be a very important point that KPK put forward in their pre-hearing statement. So I wonder if you could explain that to me.
Yeah, so I can give you my general opinion, I guess. An isolation gate valve, as I'm understanding, is just a metal section that comes down to establish that closure, and so as that comes down, if there's debris, it can't complete that closure 100%, which was our best interpretation of the root cause of the gas release.
And so you're saying it's an isolation gate valve, not just an isolation valve, right?
Yes. For simplicity, I think it's just been referred to.
And that last question, you had indicated, and this is a quote from you, that an active gas release is a serious event. Is it fair to say that's a major event?
I don't know. I would have to understand why you would want to use it or define it as a major event.
Well, I'm just interchanging major and serious. I mean, it's a serious event.
Yeah, I would confirm it's serious. I mean, if it's semantics, then yeah, it's major.
Okay, thank you.
I'm not seeing further questions from commissioners. Mr. Jacobs, I will give you an opportunity for redirect if you so desire.
I have no further redirect this witness.
Then I believe this witness can be excused, and we will turn to your next witness.
Thank you.
Thank you, Mr. Knopf. If I may, could I get a time check from the hearings manager?
Yeah, let's stop the clock and do a time check. And
Yes, so one moment, let me get to my spreadsheet. So KPK has used 47 minutes and 5 seconds. Staff has used 37 minutes and 48 seconds.
I would like to call Mr. Manuel Silva. Mr. Silva, please state your name and position for the record.
My name is Manuel Silva. I am production supervisor for KPK.
And how long have you been employed by KPK?
I've been employed for 16 and a half years.
And were you always production supervisor?
No, I started out as a lease operator and slowly worked my way up.
So you have a lot of experience with KPK's operations and properties?
Yes, I would say so. 16 years of being out in the field, you learn a lot.
We've heard a lot of testimony about isolation valves and who closes them when responding to a release, and who performs functionality tests. As production supervisor, do you have responsibilities for any of those things?
Yes, as the production supervisor, majority of the time we are the first group of people on site on any spill called in or incident. So it is our job to isolate the situation and isolate the pipeline so we can get things blown down and taken care of.
The isolation valves that were closed, as described by Mr. Peterson and Mr. Knopp, would you or people under you have turned those valves to the closed position in response to both the original release and the active gas release that witnesses have been discussing during this NOAV?
Yes, we would have been the first on the scene on September 19th to shut in the wells, isolate that section of pipe, and meet up with the back truck to commence to blow down the system.
And who would be responsible for what group within the company for the conduct of functionality tests on isolation valves?
It is the production side to maintain them. Since we operate the valves by opening and closing them, it is our job to determine whether it is working or not.
Did you perform a functionality test on the upstream valve in question that is believed to have been the root cause of the repressurization of the line due to debris, as claimed in our filings, or people under you? Did you perform that functionality test?
I did not do that myself, but I do have a group of people that do perform these tests, and we tested this valve in question with 2 pressure tests to make sure that it held pressure.
And it passed those pressure tests?
Yes, it did.
And I believe we heard prior testimony that your operating pressures for these lines are in the 20 to 40 pound range. Is that your understanding or knowledge?
Yes.
And what level of pressure did you test the valve at?
I did not do it directly myself, so I do not recall what pressures it was tested at.
Okay, fair enough. I have no further questions for Mr. Silva at this time.
Ms. Rosenberg, any cross-examination of this witness?
Maybe just one. Did you submit to the COGCC the records of these functionality tests on the 19th?
Yes, the functionality on the 19th. No, the test wasn't done till after the repair was complete at the time, because we did not want to add any pressure to the valve, to put any more pressure on that valve just in case it did not hold. We waited until the hole was repaired, and then we were able to isolate one side of the valve to test, and then test downstream of the valve.
Thank you. Sorry for my misunderstanding. No further questions.
Mr. Jacobs, any redirect?
No redirect. Thank you, Mr. Chairman.
Commissioner McGowan, question?
Thank you, Mr. Chair, and thank you, Mr. Silva. Do you know when those valves had been tested previous to the discovery of the leak, when they had been last tested for pressure?
I know we perform a yearly flow line test, so I couldn't give you exact date, but I do know that we turn that in yearly. So if we were to look through records, we should find it.
Commissioner Nanjapa?
Mr. Chair, and thank you, Mr. Silva. So are you saying that there are records of the testing that occurs annually?
Flow line tests, yes, we do those yearly, and we do turn those in.
And so you do keep records. Those are things that we could potentially look at.
We should have them, yes.
Okay, thank you.
Commissioner Messner.
Thank you, Mr. Chair. So it was indicated that you don't keep maintenance records, though, is that correct?
No, but I would assume that with the flow line test, we would know whether the valve was bad if our flow line failed. We'd have to isolate the situation if we did not pass. So then we would then go through it to verify what our issue is.
So the maintenance plan that you have revolves around flow line test and flow line test only, or are there other elements? I mean, I guess, do you have a maintenance plan?
Well, yeah, the guys grease all valves and all the moving equipment periodically.
But no best management practice, no standard for a maintenance plan, nothing in a manual that we could look at?
Not that I'm aware of.
Okay. So I'm trying to just understand quickly here. We've got this functionality test on the valves after the 23rd that ensured that they were functioning properly, but yet we had a repressurization on October 1st. What happened in that situation?
I'm assuming there was some type of debris inside the valve that did not allow it to seal. So when we depressurized it, it must have removed or dislodged whatever item was in the valve that was causing it not to close all the way.
So we got multiple instances of that debris in the valve.
Well, that's what we assume that what it is. That's what it was, because we did not verify anything, and when we performed our test to tell us whether we needed to remove it, everything passed. So once we performed our test and everything passed, we were pretty sure that there was something that was keeping the valve from closing all the way, because once it passed the test, it obviously closed all the way.
Okay, thank you.
Commissioner Nanjapa.
Thank you, Mr. Chair. And Mr. Silva, just one quick question. I asked this of the prior witness too, but do you know if there was discussion about replacing the valve, given that it had failed multiple times and that there wasn't an ability to confirm the presence of debris?
Oh, sorry. That's why we did 2 tests on it. One test for each side of the valve to make sure that it did hold pressure. That's why there was 2 tests performed, testing each side of the valve.
Thank you. And I may have missed this, but I think this was asked previously, but when was that test performed? Was that on the date of the staff inspection?
No, it was, I can't tell you the exact date, but I'm assuming after the repair was complete is when we did that test.
Okay, and then after the subsequent failure in October 1st, was there any discussion about replacing the valves?
That's why we did the test on the valve.
So that was after the second failure? Or I guess actually the third.
I only know of one failure of the test of the valve. And that was on the 23rd from what I'm getting at, when we went back and blew down the valve or blew down the line, isolated the situation, and then a few days later installed temporary valves. And then once we were installed our poly pipe and everything was ready for service, then we committed the test for that valve to make sure that it held.
Okay, so this was after those other instances that were noted that after the 23rd, there was at least one additional instance where the pipe repressurized. So this was after all of that?
Yes, this was after the 23rd that we performed these tests.
Okay, thank you.
Commissioner McGowan.
Thank you, Mr. Chair. Can we get clarity whether there actually was another incident on October 1st? I think this seems very fuzzy to me.
I don't know of the incident on October 1st. It doesn't ring a bell with me. Like I was saying earlier, the only incident that I heard of was on the 23rd when staff was there and I met up with Matt, and Matt said to give me a call.
I believe witness Knob did testify that there was another pressurization instance on the 1st, that Mr. McLaren noted it and they went out and noted it as well.
Okay, but that must have been after then we installed the temporary valves due to that situation.
Further questions from commissioners for this witness? Give me just a second, Mr. Jacobs. Okay, not seeing any. I would give you I'm going to do this pretty much throughout the hearing. I think that it is only fair that you have a chance to redirect from questions from commissioners. So I ask you if you'd like to redirect.
Thank you, Mr. Chairman. I appreciate the opportunity. Just a question or two for Mr. Silva. I believe that there was some confusion from Commissioner Messner and perhaps Commissioner McGowan about there being a second instance of debris assumed as the root cause of repressurization in the valve. But I want to clarify that if I can with a couple of questions, sir. So was the repair completed prior to September 24th, to your knowledge?
I can't recall. I'm not sure. I can't answer that.
And certainly it's possible, since you don't remember, that it wasn't completed prior to October 1st. Would the isolation valve with the debris upstream in the closed position to keep the line depressurized as much as possible, would that have been open prior to either your installation of temporary valves or your completion of the repair?
No, the valve would have maintained closed until completion of the line being repaired. Even if
only when it was open would it have cleared of debris perhaps, and then do you know of any second instance of debris fouling that valve?
No, I do not.
That's all I have. I was just trying to clarify with this witness. I would offer that I could recall Mr. Knopp for a question or two if there are no objections, for purposes of trying to clarify this point for the record and for the commissioners.
Commissioners, what's your pleasure? Do you want to recall Mr. Knob on this particular issue? And I also, if we decide that we think we might want to do that, I would like to hear from Ms. Rosenberg.
Absolutely.
We have no.
Go ahead, Ms. Rosenberg.
My apologies. Sorry, there was a little delay there, so I wasn't sure. We don't object.
Okay. Why don't we bring Mr. Knob back for this limited question to clarify this issue? And I think he's in the same room as Mr. Sola, so should be pretty quick.
He's not present at the moment, so I will. I will get him. I will get him for you.
Give us just a moment. Thank you.
Yep. As we're waiting on Mr. Knob to come back, or Commissioner Najapa, did you have a question?
Yes, thank you, Mr. Chair. I was just going to suggest or ask if it would be possible to also hear from Mr. McLaren once more related to these instances of repressurization I believe Mr. Knob had noted that the second instance was also something that he discussed with Mr. McLaren. But maybe that would be dependent on what he testifies here.
Let me hear from Mr. Jacobs on that point. We're still waiting on Mr. Knob, so we might as well make good use of this time.
Well, I haven't listed Mr. McLaren as a witness, and I wouldn't be calling him now, would I?
Well, I guess my question is, would you object if we brought him back too, just to clarify the record? You're muted.
I don't have any objection if you wish to recall Mr. McLaren.
Okay, why don't we
So we
bring
can get this straight. If
McLaren
he's
back to
available.
the panel if he's still with us. And Mr. Knob, thank you for rejoining us. Can you clarify the issue of the first pressurization on the 23rd, and then you spoke to an October 1st second pressurization, and there's some confusion amongst the commissioners about that. If you could explain what happened on and around the 1st of October, that would be helpful.
Yeah, I apologize. I was referencing the incorrect date. Looking at the facts, I know the valves were.
Please speak up.
I apologize. I had referenced the wrong date. I was going off a IR camera recording that was on file, and it was noted for October 2nd. I believe that was recorded with the completion of the stinging of the line to verify there was no vapor present then. So I made the incorrect reference that was the camera recording that had followed Mr. McLaren's observance of the repressurization. But looking at the details, I do know the temporary isolation valves were installed on the 25th. So so that repressurization date, I think I said I thought it was October 1st was incorrect. It would have been before the 25th when the temporary valves were installed.
Point of order.
Yeah, go ahead, Mr. Jacobs.
I believe that was in response to your question. Does that count against my time?
No.
Okay. Am I on the clock now, or do you wish to have more commissioner questions?
Why don't you have more commissioner questions, and then your clock won't be running and your questions may get answered.
Excellent. Thank you, sir.
Commissioner questions. Commissioner Messner.
Thank you, Mr. Chair. And so I'm going to try to get this right, okay? Because I've asked this question before. I've gotten now 2 different answers from 2 different people, so I'm trying to get this accurate. You had indicated there were 2 pressurization events. Was there 2 pressurization events? One on the 23rd and one later on?
My memory, I believe there was. I don't know this. I mean, obviously the second one, I'm not positive of the date, but I mean.
But there were 2 pressurization events.
Yes.
And both of those pressurization events had COGCC staff present to observe those particular situations.
Yes. So
both of those were due to malfunction, debris, operation issue, in your opinion, of an isolation valve or an isolation gate valve.
That's correct.
Thank you. To me, that answers the question.
I'm sorry for the confusion.
Commissioner Nanjapa.
Thank you, Mr. Chair. Thank you, Mr. Knopf. So there were these 2 events. Were there additional? Because you did make a comment when Commissioner Messner asked you the question that you were constantly having to bring a vac truck to the location and checking daily to ensure that there was no repressurization. So can you just clarify that comment? And were there additional repressurization events after?
No, there were no additional events once the temporary valves were installed. So
what were those remarks in reference to? I'm just trying to understand.
That was just our mitigation strategy associated with the grade 1 gas release. We were doing daily checks and daily vac truck activities to keep the line depressurized.
Other questions? All right, I think we're good. Thank you, Mr. Knob, for coming back and presenting to us to clarify. Mr. Jacobs, did you have anything further?
Not of this witness.
Okay, do you want to call your next witness?
We have some mini closing of counsel. My colleague, Mr. Satterley. Where is that?
Yeah, absolutely. You want to consult with your colleague, go ahead and do that offline. Is that right? Or are you calling Mr. Satterley as a witness? I'm sorry.
I'm calling Mr. Satterley as a colleague and a lawyer to present some brief argument on penalty associated with the facts and evidence that you've heard. Much like Mr. Farron did as a witness, though trained as a lawyer, he's not in a non-lawyer position. And much like we discussed earlier, many openings and many closings.
Hold on just a second.
For that.
Yeah, hold on just a second. So your case, your defense, you're basically rest, and you want to do a closing with Mr. Satterley speaking to that. Is that right?
That is correct.
Okay, hold on just a sec. Okay. Okay, sorry. Yes, Mr. Satterley, you are recognized for closing. I do remind you that this goes against your time. I don't think staff desired to do closing, and that's strategy-wise you guys' call, but we do recognize Mr. Satterley, and I'm sorry, Mr. Jacobs, if I was confused about the next step in this proceeding.
No problem. Thank you.
Thank you, Mr. Chairman. I'll be pretty brief here in the interest of time and efficiency, but my role right now is just to outline some of the Commission's rules and policies on civil penalties, and including some of the general principles and considerations the Commission is directed to take into account when assessing penalties, should the Commission decide to do so for any of the violations alleged in the NOAV at issue UPRR, Pan Am Consolidated Flow Line. So first, it is KPK's position that staff has so far failed to provide information sufficient to demonstrate that its requested penalty is consistent with the Oil and Gas Act, the Commission's rules, and its penalty policy as it is required to do so, and for which it has the burden. Second, a reminder that rather than undertaking an objective analysis of the penalty policy, as staff might do in the settlement context, staff is directed by the penalty policy to seek the highest penalty amount allowed under the Act and the Commission rules when an NOAV proceeds to hearing. Therefore, the penalties that have been requested by staff in its pre-hearing statement are inordinately high because staff did not take into consideration the appropriate penalty adjustment factors that are set forth in the Commission's rules and its penalty policy. So for this particular NOAV, staff has requested a total penalty of approximately $206,000. $206,000. And to the extent the Commission finds the KPK to be in violation of any of the allegations that you just heard about, there are several penalty adjustment factors that we believe should be applied to adjust any amount that might be assessed. I also direct you to Exhibit LLL, which provides a more complete analysis of these penalty adjustment factors as they pertain to this and each of the other NOAVs that you will hear about in this matter. But in the interest of time and efficiency, I don't intend to go through the worksheet or put it up on the screen during the hearing, but I pointed out for the commissioners' later use and consideration. So first, for the Rule 1102I violation, the first penalty adjustment factor would be prompt and effective response. And as you heard from testimony of KPK's witnesses, KPK demonstrated a prompt, effective, and prudent response upon becoming aware of the affected flow line at issue. KPK commenced actions to correct the flow line repressurization as soon as possible, It did not continue to operate the affected segment of the flow line while it was being corrected. And then promptly upon receiving notification from staff, KPK performed those required actions to shut in and isolate the failed section of the flow line in furtherance of necessary repairs. The second penalty adjustment factor is duration. We believe that this penalty should be at most a single-day violation. And as Mr. Farron pointed out earlier, Rule 525B provides that the end date for penalty calculation is when corrective action is commenced, not when corrective action is completed. So that is, once near-term corrective actions are commenced to address the situation, penalties are supposed to stop accruing. While it's true, as Mr. Farron pointed out, that Rule 525 uses the phrase corrective action to the director's satisfaction, this is really just an arbitrary term. It does not confer upon staff some form of unfettered discretion to extend the penalty dates beyond what is plainly contemplated by the term commence, as opposed to the term complete. The rule actually provides a few examples to illustrate what constitutes commencement of corrective action, including immediate actions necessary to assess and evaluate whether there are potential impacts, and other near-term actions to stop, contain, or control such impacts. So in this instance, immediately upon being notified of the release, KPK responded to the incident. They mobilized the vacuum truck to the location, completed flow line depressurization, and conducted the OGI camera survey of the exposed section of the flow line to verify depressurization. The second penalty adjustment factor that we believe you should consider is reclassification. So in accordance with the penalty policy, this should be reclassified from a major to a moderate rule violation because staff has no evidence that the incident had any actual significant adverse impacts. All of those words I just said have meaning. Actual as opposed to threatened or theoretical, significant, adverse impacts. So by rule, a major, or this is from the penalty policy, a major violation occurs when there are actual significant adverse impacts to the environment or public health. Whereas a moderate violation occurs when there is a threat of significant adverse impacts or a moderate actual adverse impact. It is staff's burden to show each of those threshold terms, actual, significant, and adverse impacts. Staff did not put forth evidence to support this threshold. As you heard repeatedly during staff's presentation, staff's inspectors were concerned that the incident could have resulted in this or that, or that the increased probability and risk of something occurring resulted from the incident. But what you did not hear was evidence that the incident did in fact result in adverse impacts, nor was there evidence that any such impacts were significant. You also heard that this incident was characterized by staff as a near miss, phrasing that suggests an event occurred that staff believed could have been significant, but it does not suggest that anything actually happened that impacted the environment in a significant way. So combined with the duration adjustment noted previously and reclassifying this violation as a Class 2 moderate violation results in a penalty of $5,000. Now, in the interest of time, I'll just point out that the same reclassification and duration adjustment principles apply to the alleged violations for Rule 1102J, Rule 1103A, and Rule 324A, but I will not go through each of those right now. And I refer you to Exhibit LLL for a separate breakdown of each. I will note, though, for Rule 324A and the reclassification principle from major to moderate, not only does staff not have evidence that the alleged violation had any significant adverse impact, but the analytical sampling results that are contained in KPK's Form 27 report confirmed that there were no impacts to groundwater or surface water. So at most, this one, like the others, should be a moderate penalty. And then finally, for the Rule 906A violation, another principle to be applied is consolidation of violations. So the penalty policy provides that duplicative violations should either be consolidated or dropped when they are not substantially distinguishable and arise from the same alleged facts and circumstances. The NOAV at issue here alleges the exact same facts for this and both Rule 1102 violations, and both are assessed a separate penalty for the same time period and for the same amount. And therefore, KPK maintains that staff should drop this duplicative penalty of $20,000. And lastly, the same reclassification and duration adjustment principles that you just heard about should be applied in the event that this violation is not dropped based on the consolidation factor that I just mentioned. That is, this should only be a one-day violation and should be a moderate, not major violation, because staff has no evidence that the alleged violation had any actual significant adverse impact. The fact that a release occurred is not per se evidence of an actual significant adverse impact. That's all I have on this.
Thank you, Mr. Satterley. At this time, Mr. Jacobs, I assume you are done with your defense at this point?
Yes, that concludes our defense on U.Per. 43.
Okay. Anything further from Ms. Rosenberg? I believe you already were done.
Nothing further from us. Thank you.
Okay. Seeing as how it's 4:54 and we were planning on adjourning at 5, I think we should just, at this point, adjourn until tomorrow morning at 9:30, in which we will take up the next NOAV. Does anybody object to that course of action?
Chair Robbins, staff does not object.
Okay.
Neither does KPK, though I would ask for a time count against our time allotment from the hearings manager before we adjourn.
Yes, so the time that KPK has used today is 60 minutes and 46 seconds, and staff has used 38 minutes and 31 seconds.
Okay. Thank you, Ms. Larson, for doing an excellent job of keeping track of time. I believe with that, we are looking for a motion from a commissioner to adjourn until tomorrow morning at 9:30 a.m.
So moved.
Second.
We have a motion. We have multiple seconds. All those in favor indicate by saying aye.
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 Any opposed? Thank you, everybody, for your participation with us today. Thanks to the 87 folks that also listened in. And we will see everyone tomorrow morning at 9:30 for a reconvening of this matter.
Thank you.